Busky, and with me this afternoon are a group of people, and we're going to run this session really kind of interactively, because there are so many different things to cover, and you all are probably going to come at this from and have questions from a lot of different perspectives. There are 4 handouts that you all should have. We ran out. And for anybody who has a laptop with them or a tablet, if you go to buskygroup.com, the handouts are on our website. The only thing that isn't is the outline for this afternoon, but everything else is up there if you don't have it. Okay. It's buskegroup.com, and it'll be up on the ACM West website soon. I'm going to, pardon? Oh, there's some extras? Who didn't get one? Get them. All right, where are the extras? Who didn't get them? All right.
More. I think I have 4.
And if somebody doesn't have them and you have extra on your table, could you just bring them over and the person raise their hand here? Before we get going, and I'm going to have folks here introduce themselves, and then we're going to kind of continue around the room, because we have people who I know who are city attorneys here. We have people who are executive directors for community media centers, and I think it will be helpful for us to know who the rest of the people are in the room, because I think in order for you guys to maximize what you're going to take away from things today, it's really good to know who the rest of the group are. So we're going to start, and I'm going to have Fred. You want to start?
No. Hi, I'm Fred Cohn. I'm suppose the recovering assistant city manager for Monterey. I left the city about a year ago now en route to an encore career that I haven't begun yet. I'm also one of the founding board members of Access Monterey Peninsula, and became board chair about a little over a year ago as I was leaving the city. And that's all I'm going to say.
Hi everyone, I'm Gail Karish. I'm an attorney at Best and Krieger in the municipal law group. I specialize in telecommunications, cable, internet, broadband, all those sorts of wireless, all those kinds of things. And I'm part of the group that you may be more familiar with, a law firm called Miller and Van Eaton. That's a group I was part of, and we joined Best and Krieger in 2011.
And I'm Annie Folger, the Executive Director of the Mid-Peninsula Community Media Center. We're based in Palo Alto. We actually, through our Joint Powers Authority, serve Palo Alto, East Palo Alto, Menlo Park, Atherton, and essentially Stanford University territory, some unincorporated county space there. I wondered why I was invited to be on this panel, and I think it's partially because our organization is a very fortunate one. We have kind of dodged a few of the bullets and are happily continuing our work with pretty much of our funding in place. So I'm glad to be here to share our story.
And let's just quickly go around the room and people just introduce themselves and tell us what organization, city, or whatever you're with. And I'm going to start over there.
I'm Becky Saunders. I'm with the Media Center. I work for Andy Folger.
I'm George Crow. I'm treasurer of CMAP, which is out of Gilroy. I'm interested in funding.
Chris Verdugo with Contra Costa County.
Brian Marchano with Contra Costa County.
Aaron Miller with Pasadena Media.
Karen Liu with the Sacramento Metro Cable TV Commission.
Clay Leander, Common Frequency, and a resident of Contra Costa County.
John Eccles with Truckee Tahoe Community Media.
Jim Horwood, I'm an attorney with Spiegel McDermott in Washington, D.C., and I represent media centers and local governments. I'm going to be doing the opening plenary tomorrow with Sue and Gail.
Matt Schuster, TV Santa Barbara.
Alan Sutterfield, station manager, Santa Maria Community Television.
Right on time. John Bertucci, Petaluma Community Access.
Autumn LaBay-Renaud, Davis Media Access. I'm the executive director. Pelayo Llamas from the Oakland City Attorney's Office.
I adjusted it and it didn't seem to change.
Melissa Cavallo, I'm with the City of Palo Alto.
Jerry Martin with Access Sacramento.
Well, wait until maybe they get back. But
Angela Silvestri, with
no.
John Borak, General Manager of the Public Cable Television Authority, Orange County.
Mike Voss with the City of Sacramento City Attorney's Office.
Amanda LaPlante, Community Television of Santa Cruz County.
Sean Rosaya, Fremont City Attorney's Office.
Melinda Stewart, Blackville City Attorney's Office.
Mark Mazzaferro, I'm the PIO for the City of Asheville.
Sarah House,
Artie Green, Board Member,
This is
KMVT
not-
15 Mountain View.
Kathy Martin, board member and treasurer of KMVT 15.
Betsy Burkhardt, Contra County. Jennifer Wayne.
Even when I was talking to them, it wasn't getting even halfway, or maybe getting to 5 at the most. And I goofed with this. I didn't do anything. And I'm worried that I turned it down too much.
Jennifer Couchot, Adrian Matheson, and Bank, we rely heavily on speaking with
Greg Ratcliffe, Peg Studio Manager, City of Lompoc.
Good afternoon, Renee Turco, City Attorney's Office.
And guys in the back, introduce, say hi.
I'm Juan Cerda, Create TV San Jose Access Facilitator, and I was in the digital workshop, but I was like, I think this is more.
There's 2 seats up here.
Okay, thank you.
Then you have to sit in the front, pretty
That's
cute.
okay.
Well, what we're going to try to do this afternoon is hopefully answer the questions that brought you to the session in the first place, and maybe maybe a few more, and also maybe identify next steps. I mean, and how do we deal with the impact of DIVCA in the state of California? Are there things we can do? Are there things we can fix? And if so, is there a way that we can move forward and take some action? That's sort of toward the end of what we're going to talk about today.
I can't clear.
I put together, we as a group put together an outline of kind of categories of things that we've been hearing people want answers to. I mean, they have to do with everything ranging from what's happening with that AT&T Los Angeles et al. Case, okay, and Gail's going to fill us in on that. How about the Attorney General's anticipated opinion from the Attorney General's office with regard to Prop 26 and paid fees? We're going to talk a little bit about what's going on with the CPUC and its ongoing state franchise renewal process, so to speak. And then we're going to dive into something that I hear a lot of questions about from local governments, and that is this whole issue of what is capital and what is operating, and how can we use our paid fees, and is the cable company going to come and sue us if we don't use them in a way that they think is correct? There's just a huge amount of misinformation circulating around that and a lot of confusion. So we're going to dive into that as well. Those are the few of the things. We're going to keep it pretty free-flowing, but I want to find out from you guys, what are some things you want to have answered before you walk away from this session?
We're recording.
You just throw it out, we're going to jot them down, so we make sure we cover them.
Right now.
Okay. Thanks.
Okay, other things. Other questions you come to the session with? Yeah.
Well, I think what you just mentioned, the capital, what's the capital? I mean, we've already basically had Comcast tell us that they're taking a very restricted view of this, and they'll challenge anything that's not spent like that.
And you're from which community again?
County Santa Cruz.
Got it, okay. Other questions you come to the session with?
No, I just want to echo the same question. There's a lot of focus on that division of what you can spend it on.
Other things?
2006 funding versus current funding as defined by DIVCA.
Okay, others?
We're not currently under DIVCA, I'm sorry, we will be in 5 years. What will I need to be, looking towards putting in place before that happens?
Okay.
But we also have a Prop 26 issue because we're just coming under DIVCA as well.
Other things? Good starting. Okay, yeah, in the back.
For carriers that are going all digital, their obligations,
So it's basically, he's saying that the digital conversion and the impact of the digital conversion on extra equipment that the citizens, the subscribers are going to have, and if we have any control or power, and et cetera, okay? Yeah?
The channel location in terms of the access.
Okay.
This question about cable border, right?
I would say DIVCA enforcement options, if any.
Other things. This is good. We got a great list going. Okay, so one of the rules of the road for this afternoon is we really want you guys to dive in and ask questions as we go along, okay? Because we don't want to sit up here and have to talk for 2.5 hours. We think you're going to get more out of this if you just dive in. If something doesn't make sense or whatever, ask a question. Because every time you ask a question, there's another question a lot of times that rolls out of that, and I think it's just very useful. So I think, okay with everybody? Okay. We're going to start, we're going to kind of follow the outline. I'm sorry we ran out of handouts. There's one more of the outline. Somebody, okay, there we go. This way? Okay. And then you can just share. Sorry. Oh, you took this?
No.
Okay, I'm sorry. I misunderstood.
This is the one that you mailed in advance, right? The outline?
No.
Okay.
Okay.
Yeah, they did.
You're making me scratch my head. But what we thought we'd do is sort of start out by kind of setting the stage with some background and explanation of the impact of DIVCA. The very questions you bring up, I think, are really good indicators of the impact of DIVCA. How many of you know the backstory and how this thing got started? Because I think it's useful to framing where we're at. A few. Essentially, DIVCA evolved because Verizon and AT&T wanted to get into the cable business because they saw the traditional incumbent cable operators getting into their core business beyond telephone, which was internet. And they were taking bigger and bigger hunks of their business. And starting in about 2001 at the federal level and then evolving to the state level, they basically laid out a strategy of trying to make it easier for the AT&T telecoms to get into providing cable service. And the best way for them to do that is to remove the authority of local governments to grant franchises. Now, this is a core basic principle of local governments, to have the ability to control their public rights-of-ways and easements, to be able to, they have the responsibility for taking care of them, but the responsibility for giving access to them and getting appropriate compensation for the use of the right-of-way. California was one of the earlier, not the earliest, but one of the earlier states where the cable industry joined up with the AT&T and Verizon's of the world and was successful. The bill started in the assembly side in 2004, then there was one in 2005, and finally 2006. The bill that came out of the assembly initially in May of 2006 was absolutely horrendous. It was essentially written by AT&T. And it was really only in about November of 2005, if I'm remembering correctly, where the traditional incumbent cable operators, they were there along for the ride, but they weren't pushing it in California till about a year in advance. And that's when they jumped on the boat with AT&T and Verizon. And as one of the senior staff members for former Senator Joe Simitian told me at the time, because thanks to Annie and the work of the folks in Palo Alto, we were able to work closely with Senator Simitian's office. There was, he said there was more money spent in lobbyists and PR firms on that bill. There was only one other thing that was electrical deregulation or something like that. I can't remember that he'd ever seen it. He'd been working in Sacramento for over 20 years. The estimate was about $45 million that went out to lobbyists and PR firms by the telecom companies to get this law ultimately passed. The first of the big states that passed the bill was Texas, and it was '85. It was 2006, January 2006. Okay, so that sort of kind of frames the backstory of how we got where we're at. The promises that were made to state legislators, not only here in California but around the country, were oh, more competition is gonna equal lower rates, you're gonna have more choice, et cetera, well, come to find out, 6, 7 years later, none of that has really come to play out. And there's a great study that was done by the Humphrey Center at the University of Minnesota that's on their website about, it was a study of 5 states, and California was one of them. And it was published in 2010, and it took a look at what the outcomes, what the promises were, what the outcomes were, et cetera. So it's something you can go, it's on their website, you just go find it. It's a very interesting piece of reading. There have been a lot of other things written too. I mean, you guys probably got, what are some of the other?
Yeah, we've done presentations and things at various events or various conferences. I think one of the most striking things, even in the areas where you legitimately can say there's a lot of competition, you have 3 providers, you don't see prices go down at all. They only go one way, and that's up. So there's, that promise of lower prices. The response the industry makes to that is, oh, but you get more channels now, or better service, or some, other bells and whistles. But they're, at the same time, I think they all have strategies where they try to make their consumers very sticky. It's really hard to switch. So even if you have competition, there's a lot of things, it's very confusing, kind of bundled packages and pricing, and it's just complicated to try and switch. So that makes the effective competition a little not as effective, and it certainly has not been at all on the pricing side.
Jim?
Well, how about more jobs, which is what CWA is supporting.
Right.
This legislation. And that hasn't happened.
No, in fact, there's been a reduction in the amount of jobs available, if I'm remembering correctly. So the bottom line is the promises that were made were not delivered on, and at the end of the day, the people who lost were local citizens and residents of this state, because no longer can local governments oversee and give access to the right-of-way and grant franchises. And there's a number of other losses. I mean, in one of the handouts that you have in your the stuff that was handed out was a list like that, and that's about 50-some places where we know that as a result of DIVCA, the community media center, the PEG access facilities have shut down, and in some cases the channels have gone totally black. And if anybody has places that aren't on this list, if you could just let me know, because I want to keep it up to date. There's probably some that I don't have on this list. So as we're sitting here this afternoon, just jot it down and bring it up at some point or after the session, because I'll put it back. It's on the website now, but we'll put it back up updated if you've got places. So one of the big impacts is that there has been a real loss of the ability for people in this state to get information out about the communities through the community media centers. And that's because either the funding was eliminated, or in some cases the city was concerned that if they used the funding for a particular kind of purpose, that they might get sued, so the city then didn't distribute the funding for the paid purpose. And we'll get into all that detail in a little bit more, but that's one of the impacts. Another impact, and we're going to talk more about a lot of these things later, because I was talking to Gail and about this the other day. I work in a lot of states where there's actually still local franchising, and I'm helping cities with franchise renewal processes. And one of those states is Minnesota. And in Minnesota, there's a lot of joint powers authorities, smaller communities gathered who franchised together 25, 30 years ago and are now going through renewal. And I'm going to bring this up because you guys probably have a better sense of this than me, but if it's impacted California. But what I'm finding there is Comcast about a year ago made a massive change to how they do customer service. And in those states where the city still has control, real controls, not just the sort of control we have on customer service in the state of California, the complaints are huge. The amount of complaints that are coming through related to the digital conversion, the amount of complaints that are coming through with regard to the packaging, in other words, the bundling and the sort of almost misrepresentation of what you're going to get for your money, okay? I mean, I've read through these, but what's interesting to me is I go and I work with these states and in these cities where they still have local authority, and all of these problems pop up. But I work with a lot, we all work together with a lot of folks in California. I don't hear that much about it in California. But it's the same customer service issue, a system that serves Comcast in California that serves Comcast in Minnesota. And so one of the things that I've noticed is that as cities lost the authority to grant franchises, the people who had the responsibility for overseeing this at the local government level suddenly were shipped over to other jobs, or the other duties as assigned piece that was part of was sort of reduced and reduced and reduced. And so we're no longer hearing as local governments from people about the problems they're having, okay? Because I don't think the problems can possibly be that much difference between what we hear, the stuff in Minnesota and the stuff here. It's the same company, it's the same, in this case, the same kind of customer service problems. Yeah.
Well, I get those phone calls for Sonoma County, and I get several a week about prices and service, and they don't show up when they're supposed to, and yeah, so I get them.
Do other people here, I mean, I know a lot of you are with local governments and.
Yeah, well, Chris and I work at night,
Uh-huh.
and when the phone rings, sometimes it's for us, but sometimes it's people looking for Comcast, and sometimes, yeah, and when they know it's not, they might start speaking right away when they pick it up on the first ring.
Are you a live body?
And then half the people that just want the Comcast number, and the other half want to know why run the bill. Some of the stuff is somewhat like a 5-minute explanation, but no, we do get probably, I'm probably about 3 or 4 cable complaints at night, and there's also a lady in our office that does it during the day. So we're still hearing. So.
Okay. And you had mentioned too?
Yeah, with Pasadena, we're actually on their cable bill, so they'll actually call us when they have problems. And so we have, so we have that, and then also on our website we have basically a place where a survey where people can say have cable complaints, and we send them on to the city. I guess the question you would like to have answered is anyone going to take on that position since the cities are no longer, local governments are no longer actually getting that information out to you to be able to kind of work with?
Yeah, one of the problems, you are still probably all on the cable bill. It's just you don't have the same level of staff that can handle complaints as you used to. And I don't have any statistics, but I know anecdotally a lot of our clients that we worked with on local franchise renewals and all kinds of, financial audits and other things that we do related to franchise fees and things like that, they dismantled or moved their cable franchise people to, community services or somewhere, maybe in the city manager's office somewhere, or maybe in finance because they're the ones receiving the checks. And so you don't have the same level of staff necessarily that can attend to problems or can address, and you don't have the same authority when you are dealing with the cable operator asking questions, because you're not the franchising authority anymore, and you're although you're responsible for enforcing customer service, the penalties in DIVCA are very low, and you have to give half of whatever you manage to collect to the PUC. So there's not even much of an incentive on the city side to spend a lot of resources, because you in the end of the day, you can't do too much. So it's like a charitable endeavor trying to help with customer service now.
So how do we as centers are we able to enforce that? Yeah, we may have less staff, but we do have other digital options that can be helpful to at least gain that information and an opportunity to be able to have some type of authority. Because like I say, right now we send it to the local government, and we hope that they call up charter and say, hey, what's going on? But go ahead.
And is everybody familiar with what your authority is under DIVCA and customer service? Because if not, I can make a deal. You can refer you to sketch it out. Or is that something you're pretty?
Well, some of us aren't under DIVCA yet.
Yeah,
so.
Jennifer.
Right. Can we talk about some more about our enforcement obligation? We were kind of struggling with that. We've got AT&T in San Jose. We've got Comcast who's now converting, but they just gave us notice for Comcast who's converting to a state franchise. So although we've been dealing with AT&T for the past 6-7 years, wondering really legally what's our obligation. I know that there's a number of code sections enumerated in DIVCA, so we have to some government code sections about customer service, the federal government resources, standards,
Yeah, so if you are under a local franchise still, then whatever your local franchise has in terms of customer service is what's going to apply until they switch to the state franchise. The state franchise holders only have the customer service obligations that are in DIVCA and the ones that are referenced in DIVCA, which are pretty minimal, pretty basic, and the penalties are also listed in DIVCA. You have to enact an ordinance, a local ordinance, to be able to enforce those minimal penalties, and that's it. It's your responsibility as a local government to enforce customer service complaints. If a customer goes to the PUC, they're just going to send them your way, but you do have to send them half or whatever you manage to collect. So it's not a pretty situation. And the theory behind it was, oh, we're going to have all this competition. That's what you hear everywhere, that, oh, the competition is going to drive the customer service. You're going to get great customer service because you're going to have all this competition. So that was kind of the theory that was kind of bought behind DIVCA.
Go ahead, go for it.
I end up with the city calls by default in the town. Most of the calls I get are about service and conversion. And I'd say half of them end by saying, I'm going to just drop off and go online and drop my cable connection, which is happening in droves in our county. So it's kind of, I don't know if the cable companies realize it, and I'd rather get onto this, I didn't want to bring it up, but they're driving people away in big, big numbers. And I don't get that many calls, maybe 5, 6 a week. Literally half of them say, I give up, I tell them I can't do much. They say, we'll just disconnect. It's a young population there, and they're just disappearing off the cable system.
It's ironic because you would think that, I mean, first of all, the number of cable subscribers nationally has been dropping slightly every year for the last maybe 4 years. It's not a dramatic drop, it's just a kind of slow. It was about 60 million about 4 years ago, now it's down to about 56, or it's really 54 million. Now the revenues, it's interesting. If you look at the customer drop, it's very slight, but the revenues just keep going up and up and up. And it's a combination of rate increases, new services that are being offered, and then of course the cash cow for the industry where there's almost no expense is the internet services. And in a lot of places, there is no real competition for the cable operator, particularly if you only have one operator as far as any kind of speed on internet other than the cable company. So you've got this sort of interesting dynamic where at the local level, you all hear about these problems, but because there's no longer local franchising, your hands are sort of tied. At the end of the day, if there was local franchising, you might have you'd have a lot more enforcement tools than just a measly little amount of penalty that you can assess the cable operators. The penalties are really pretty modest. And also the customer service standards that Gail was referring to are customer service standards for the most part which were adopted at the federal level probably 20 plus years ago, okay? And at the state level, the original customer service language that I remember, it probably goes back as far or longer than I can't remember the citation, but there's some pre-DIVCA customer service standards in California. And so it is just a catch-22 all the way around. I don't think that anybody is looking at the impact of this, again, on particularly more rural communities, places that are not urban and suburban and who do not have as many choices and who do not have the bodies to really document the impact on consumers. This is the kind of stuff when we start to think about what do we need to be telling our state legislatures and legislators, and what does the I mean, ultimately, we could say it's a CPUC, but it's not the CPUC. I mean, when DIVCA was adopted, the Senate co-sponsor said that this bill has a lot of things that are not being addressed and that the legislature is going to have to go back and readdress them. And to this day, none of those things, there's been no readdressing of any of those issues. And renewal is one of them, and we're going to take that up in a little bit. I don't know, Fred, if you had any thoughts from your years of tenure there with the City of Monterey on the customer service side.
Yeah, as Gail mentioned, I think the lack of teeth is key. Back when local government did have a franchising responsibility, I know in our case, we kept very copious logs, customer service issues and complaints, and tracked them through to resolution. But under DIVCA, the ability to do most of that is gone. The minimum customer service standards are very weak and diluted, and frankly, just wasn't worth our time. And as local government got skinnier and skinnier, this is one of the things we just stopped doing because there wasn't that return there. It just didn't make sense. And if people were concerned, we say this came compliments of your state legislature and former governor, and if you have concerns, you might want to let them know. But basically, all we really did was give the customer a number for a live body we knew happened to be sitting up here, in this case it was San Jose, that might be able to resolve their concern. And sometimes that worked and sometimes it didn't.
Now I would tell customers that call in with a complaint to send a complaint to the PUC in that renewal proceeding, because
That's a good one. I've tried that and people just go, yeah, right.
The other thing that's just sort of a by the way, but Sue touched on it, is, for the rural areas and the areas that aren't really intensely developed and populated, when we had local standing, we had the ability to specify a minimum infrastructure to support the entire community. Right now, that is left up to the crafty devices of the operator, and as much as they promised that they wouldn't be cherry picking the more desirable neighborhoods, that's exactly what's happening. And we're finding, especially in the rural areas, a lot of people, a lot of communities that just aren't being served well at all, and that's, to me, a major travesty.
For those who are interested in one thing that was handed out at the overview of DIVCA, on page 4, there's just some bullet points about build out and non-discrimination requirements. These are just things that I kind of bulleted out there in DIVCA, and there are in fact some build out responsibilities that the cable companies have, but they're sort of tied to where they build and their percentage of the areas where they build had to be. So if they choose not to build at all in an area, the anti-redlining stuff that really doesn't kick in effectively.
I think it's the telephone corporations, right? Wasn't it the telephone companies that had the build out requirements?
Yeah, depending on if there were fiber, Verizon is, if it's fiber to the house, it's one standard. If it's a not fiber to the house, which is, in other words, if it's Verizon, it's one standard. If it's AT&T, it's the other standard.
Right. But they are pretty low percentages. When you think about the historic cable franchising would end up with 80–90% build out. I mean, that's how we got to having that level of broadband available in the country, really, is because of cable franchising build out requirements. Those are far removed from those standards.
Yeah, the specifics are in there in case you're right in that handout, in case you're interested.
Sue, is there a difficult ordinance and how important that is to at least do something?
How many of you who have state franchises have passed a DIVCA ordinance? Something that incorporates your authority and lays out. How many of you who have a state franchise have not passed an ordinance that preserves your rights under DIVCA? Do you know what we're talking about when we talk about DIVCA ordinances? I just want to make sure. Okay. And it's something a friend and I were talking about, is that you need to pass, and this is, every once in a while I still have some smaller communities that come in and say, yeah, we need help, but I know that's something that Monterey was on top of it right after the bill was passed. I think you guys did yours, right?
And AT&T fought it tooth and nail. Comcast was okay with it, but AT&T just screamed at everything we were trying to accomplish, and we said, no, we have some rights that are reserved to us, and we're going to exercise them. And finally we put that to rest. They attempted to go political, but again, it's a stopgap, and it doesn't accomplish as much as we need to accomplish.
One little caveat around that, and this is just my personal preference, for those who haven't done it, there's some cities I saw who had part of their city code that dealt with local franchising, and they were eliminating it completely. And then they were adopting something for state video service providers. And I recommended to people not to eliminate it. simply to add another section that deals with state. So you maintain what you have for local. If ever anything evolves, ultimately, that some of this authority could possibly ever roll back, you've still got it. And I know it probably sounds kind of ridiculous, but you know, I'm a hopeful person. and maybe someday something will happen at the federal level that'll impact the states, then maybe we'll have some additional authority. But it's just something, if you haven't done this yet, and you have language in your current city code that deals with local franchising, I wouldn't recommend eliminating it unless it's extremely ancient and you need to hit the refresh button on it, but you definitely need to have a difficult ordinance. Okay, so we wanted to make sure we kind of touched on that. Let's dive into, maybe, if it's okay with everybody, some of the PEG issues. Because there were a number of things that you guys raised, and I'm going to start out and hit on, if you look at the, we'll hit on PEG channel capacity, functionality, number of channels, that whole can of worms. If you look at that handout again, the overview, if you look at page 3, you're going to see a set of bullets that deal with PEG channels. So again, this is something that it's just sort of a jumping off point for what we'll talk about. I'm going to, probably the biggest, no, we're out. I'm sorry. Is there anybody have an extra one or sitting next to somebody you can share with in case some folks, just raise your hand anyway. The initial biggest elephant in the room right after DIVCA was passed and AT&T started offering service was the whole in AT&T's Channel 99 drop-down menu goodie with regard to access channels. And there's all three of these people have dealt with it. They were sitting here at the table. And so I'm going to kind of turn it over and maybe start, Annie and Fred have dealt with it from the local perspective. Gail's going to give us an update on the litigation that's been going on, or give us some background on the litigation and the update. And maybe you want to start and then we'll bounce it through.
You want to start with kind of how people addressed it?
Okay, well, Annie, Annie was one of the early ones with the Access Corporation in Palo Alto and that dealt with it.
So you're talking about how AT&T came in?
Is everybody familiar with what we're talking about? Okay, good. Just one to know. Okay, good.
So this is about how they installed and
yeah, well, basically, let me frame it a little bit, and then I'll bounce it to you. The issue really is that the mechanism, the way you access channels, okay, on an AT&T system is not like a regular channel. 12, 13, 14, 15. You go to channel 99, and then a menu drops down, and then you're going to see a whole list of cities. And then you're going to find, but you have to go through them. And if you're in Vallejo, you're a big, deep dude, because you're at the end of the list, okay, or anybody with the W's or the B's or whatever, okay? And then you go through a number of steps. And actually, the DRA at the CPUC got very involved in this for a while. They had some warnings on their website with regard to the issues that were surrounding it. So it was essentially violating, if you look at section 58, 70G3, I'm sorry, but if you want a citation, there it is of DIVCA, okay? It talks about the fact that all video service providers must provide PEG channels of similar quality and functionality to the commercial channels on the lowest cost tier of service. This certainly doesn't appear to be of similar quality and functionality to the other commercial channels on the lowest cost tier of service. So the concern is and still was and still is, doesn't this violate the state law? So the dilemma that local community media centers had are, do we allow AT&T to carry our access channels or not? Because it's not going to be the same. And so with that set up, Annie, and then Fred, take it away.
So there are a number of things. Just on the functionality, early on in the new Channel 99 introduction, we went up to Pleasanton to get a demonstration at the AT&T headquarters. And the system, their software thing that had to mount up, crashed twice when we were there. it was really laughable, and you know, and it got worse. But it was just curious that even when they were trying to demonstrate something to us, it wouldn't work. I ended up doing 3 different demonstrations of the comparing Comcast on a split screen with AT&T, and we used a digital chess timer, you know, for place, and we had that on top of the TV. And so we started it, and then we talked about how you had to go through, and of course we were trying to get to Palo Alto, and at that time there were only 10 pages that you had to scroll through. Now there are even more, because I don't know, there's so many systems listed all over the Greater Bay Area that it's just, you know, you just have to scroll and scroll. So I've got one demo where it took 1 minute and 5 seconds from when you got to channel 99 to when you actually got to a council meeting on channel 26 in Palo Alto. Okay, I did another one that it only took 39 seconds, and it was a miracle, but 39 seconds is a long time when you're used to going click, click, click from one channel to another.
But also you're computer literate, right?
Exactly. Well, it's interesting. We got one complaint from a guy in Palo Alto who was very proud of himself as being a very, you know, one of these startup guys who was totally computer literate from the word go, who could not find our council meetings. And he said, I'm so embarrassed. I've got all these skills, but I can't get my channel 99 to work. Anyway, at one point I was called upon to represent the ACM and appeared before the telecommunications subcommittee back in Congress. This was in January of 2008. And while I was giving my oral testimony, we had the demonstration running on a big screen over my shoulder so people could see all the permutations of clicking and waiting and clicking and waiting till the channel finally came up. So that's one side of the story. The other side is in Palo Alto we have 2 educational channels that are run by, one is run by Stanford University and the other is run by the Community Cable Network, which is a coalition of the community colleges. It's DIVCA College and Foothill College. And Stanford went ahead and went through the process of getting the AT&T service. On the other hand, the fellow at DIVCA who was in charge really concerned for how AT&T was deciding to make our community channel subpar compared to commercial channels. And he was totally, you know, on our side in terms of we're just as legitimate as the commercial channels and deserve to be on the dial. So the community colleges in California are required by law to provide closed captioning for all their students. And very important in the closed captioning way it happens is when you press closed captioning, the captioning comes up on a regular cable channel, but it essentially blocks out part of the screen. So I'm saying this because if you are not you know, AT&T's solution was let's just run the closed captioning all the time. Well, if it's a professor's PowerPoint presentation and you've got 10 points, 4 of them are covered up by the closed captioning and you can't read what's on the slide, you can, you know, anyway, it was crazy. So the fellow at DIVCA decided that he was not going to be part of Channel 99's lineup because to do that would be to break the law that he was required to behave by. And even after, you know, years later when AT&T came up with their solution for running the closed captioning, he still declined because he said, in his words, accepting their substandard way of offering access channels to the public simply gives them more credibility, and I refuse to do it. So it was interesting, and he was one of the ones that I mentioned in my testimony before Congress because the abilities community needs the support, and there are state laws that require that support, and for a cable company not to offer it is just not good.
Fred, you would talk about?
Yeah. A lot of the things that Annie and Sue talked about were resonating with us as well. First of all, as background, we were really active in the anti-AB 2987 effort, and of course, that wasn't successful, but it left a bit of a foul taste with some of the leadership in our community and our city council. And as AT&T began deploying their system, we were concerned about things like the Channel 99 issue and the delays, the image quality on the channels, the closed captioning, those kinds of things. And we made the decision that we're investing a good amount of resource in making our public meetings very high quality in terms of the packaging and presentation. And AMP did a great job supporting us in that and getting that on the system. And at a very high level, we decided we're not going to put that product on an inferior channel. And we sat with that for a while. Interestingly, it was very quiet in the community because AT&T's penetration was so low, there wasn't much pushback on that. We actually considered joining some of the litigation that was starting to circle around at the time to press this issue with, in our case, it was AT&T. We decided not to do that just because we carried a lot of water earlier in the story and had other things we needed to be doing, and I was off to other things and my time was spread thin, so we sort of just let that go for a while. And eventually we were starting to get some squawks from some key people in the community, and we just decided to bite the bullet and put the signal on the AT&T system. And if others were successful in pursuing changes in how that was delivered, we would certainly benefit from that. Interestingly, AT&T was really hot to go to get this going quickly, and we had a barrier in our community media center in terms of rack space for the AT&T equipment. And the solution to that was pretty simple. We also had in that same head end equipment for an iNet node that was at that facility. We were moving that iNet rack out of there to a city facility, but until that happened, we just didn't have rack space to accommodate AT&T. And finally, that was all squared away. AT&T came in, they set it up, they started delivering. We got the inevitable calls saying this doesn't look very good. Matter of fact, we had a councilman, vice mayor at the time, who actually took the Kool-Aid and went over to AT&T and dropped it within 60 days to go back to Comcast and very publicly announced that AT&T was an inferior system. But we got the occasional complaint. We told them to call the PUC and talk to their state legislators that voted for DIVCA and kind of just put it behind us.
Fred and Annie, did you guys, did AT&T cover any costs you guys had to do for them to get the signal, or did you have to pay those costs?
In our case, AT&T covered everything. They set up the T1 circuits, which was bizarre to me that they were using T1 lines for this, and brought in the equipment. And as I recall, there was no cost to the city or AMP for that. That is going to be an interesting discussion in the next couple of months because AMP is moving to a new facility, and with that, we'll have our iNet connection to keep feeding Comcast, but AT&T is going to have to be moving literally across town to support the feeds, and we're not quite sure how that's going to turn out yet.
Yeah, we didn't have any costs either, but initially they were insisting that they needed to have a locked separate rack somewhere. Finally, when they came to our building and saw that room was a secure one, they agreed to use our existing racks. They did use the T1 lines, and I think we have 5 channels. They installed 1 extra line for some redundancy. We don't have anything to do with it, but they occasionally come out and make a repair, so we assume that something went wrong. And that's the other thing, they wouldn't give us any way of monitoring the channel as it was being received by the customer. They did give us a way that we could look at the signal as it was going out of our facility, but we have no way of knowing, what people were getting at home. So,
and we're going to kind of come back to this bigger issue of the obligation to connect to the origination point. But I want Gail to pick up on the litigation that Fred started to talk about and what evolved with that.
Sure. So a lot of communities were faced with this choice in 2007, 2008. AT&T is coming to say we're going to start providing service in your community. And by the way, this is only an AT&T issue, right? It's not a technology issue. It's not an IPTV issue. It's AT&T's architecture of their system and the choices that they made in developing it, that they have decided to aggregate the channels at a DMA level, designated market area level. And so that's why you end up with a bucket of PEG channels that might be 200, 300 PEG channels in a large DMA, right? In Los Angeles or in the San Francisco Bay Area. And so it's just their choices in terms of their network design that made them choose, or were they elected to go the route of a Channel 99 platform. I think it's pretty fair to say, and I'm speculating, but I don't think it's much speculation, that they anticipated that there might be some pushback on this Channel 99 arrangement or platform. And in DIVCA, I just want to read you one subsection that's dealing with enforcement of the PEG requirements. So it's 5870P. It says, a court of competent jurisdiction shall have exclusive jurisdiction to enforce any requirement under this section or resolve any dispute regarding the requirements set forth in this section, and no provider may be barred from the provision of service or be required to terminate service as a result of that dispute or enforcement action. So go to court. That's the most expensive way to try and resolve the issue. And by the way, whatever remedy you get, you can't make us stop providing service. So some communities decided to go to court. And they actually, it's an interesting group because it's the City of Los Angeles, the Sacramento Metropolitan Cable Television Commission, and the City of El Segundo. And they made different choices about whether to allow their PEG channels or the government channel, any of their channels to, local channels to appear on the AT&T platform. The City of Los Angeles just said no. The other two said, we don't like this, but we want to be on your system. So that litigation, that was a complaint that was filed in 2009. It's now 4 years later.
And how many $1 million?
The complaint basically said, you're violating DIVCA, you're not providing a channel. The response in the most simple terms is, no, didn't you read there's that little language in there? Well, what's a channel anyway? That was one of the responses. A channel? Well, what is a channel? I think we're providing a channel. And the other response was, there's some language in there about feasibility. It's just not feasible to give you whatever you want. And that's our out. So that litigation has had a lot of experts involved, a lot of AT&T lawyers, and no resolution yet. So there was a motion for summary judgment that was, or summary adjudication on some of the issues that was brought by the plaintiffs and we represent the plaintiffs, by the way, brought in 2011, and that did not resolve, that was denied without prejudice, did not resolve the issues. They continue to do discovery and have settlement conferences, and here we are 4 years later with necessarily no end in sight. So that goes back to my basic point, which is, I think that they thought about this and they got what they needed in the legislation, which is take the most expensive route to try and solve it, and you can't turn off for service anyway. So kind of frustrating story, but that's where we're at.
The other thing that's sort of interesting about this, and Gail, you may be able to share more, is there are three video service providers in Sacramento: AT&T, Comcast, and a company called Sure West. And Interestingly, I had the opportunity to tour the Shore West facility with a representative of CPUC at the DRA, probably about 2009. And what we learned was that the software and the approach to signal delivery, that the software that was being used by Shore West was essentially, and the middleware was essentially the same as what AT&T was doing. So in my non-technical, and what we were hearing, the Shore West people didn't actually say it, but between the lines, it was pretty clear that there really wasn't a technical barrier to AT&T offering a full normal channel like Shore West was offering with regard, because they're using very similar, I won't say identical, but very similar software and middleware. The key, as I understand it, was the middleware of the deal.
And where they aggregate.
And where they aggregate, yeah. So, and that's just another little piece of the background of this, that there's a constant sort of banter that it's a technical issue, but it kind of doesn't look like it.
Some minor trivia regarding AT&T's 99 menu. If you go there, it doesn't say public education and government access channels. It says government education and public access.
Yeah.
Because it's GEP.
You know, and there's an interesting phenomenon, and it may make some of this academic, I don't know. I know at least in our community, AT&T's penetration is still very low. You know, we know that from the franchise fee proceeds. I mean, Comcast is having their lunch, and it's largely because AT&T is putting an inferior product out there. I'd be curious if any of you are seeing examples where AT&T is gaining substantial share compared to the cable guys, the traditional cable guys, but in some ways the marketplace is telling AT&T they don't like what they're offering, and you know, AT&T was asleep at the switch before DIVCA, and they went to change the rules to try and catch up. They're still not catching up.
Just go ahead and fire away.
I'm going to say that in contrast, where Verizon has come in as a second provider, they've done extremely well. Their system is not at all like AT&T's. The tech channels just look like all the other channels. And a lot of communities I'm aware of, Verizon is now the #1 provider, and they've outstripped Comcast or the other traditional cable operator, because they're delivering a product that isn't inferior. There are other issues that we have with Verizon, but the quality of their product has been fine.
Yeah, that's a good point.
And it's basically because they did fiber to the home, and AT&T did it to the neighborhood.
And then we used their old twisted pair to get to the house.
Yeah.
So here and then.
Fred, the example you just gave, that AT&T seems to have a low penetration compared to Comcast. There used to be statistics going back 20 years of those communities that supported a good array of PEG programming tend to help with the retention. Do you think that's a factor here?
No, I see what you're saying. I don't think that was a big influencer in Monterey's case. We certainly weren't playing that card. I think the public was figuring out all by themselves. And AT&T was hurt further because they were cherry picking within the city limits of Monterey. And it just was apoplectic about it.
Yeah.
When you're done with this, could you, we had some issues that everybody brought up in the front that I thought were the exact ones we had, like Prop 26, the capital versus operating. Could you start going down that list, please?
Oh yeah, that's coming next. Yeah, that's the next thing on our outline, is to go into that direction. One other thing, and I bring this up only because I have heard, particularly from some cities that have Charter as their incumbent operator, that they are charging for the connection from the origination point, whether it's City Hall or the Community Media Center, to get the signal from there to the head end of the cable system. Has anybody in this room encountered that? I know it is happening now in Long Beach.
Well, that would be Nick Grant that would know that, or Captain 50, right?
basically, and this is something to be aware of, is I don't know, AT&T, as these guys mentioned, tried to get them to pay for the connectivity, the connection, to be able to move the signal from the origination point for the local content to the head end, okay? Charter has done that also in some places and frankly gotten away with it. And you should be aware that although the language isn't perfect, there's language in DIVCA in section 58, 70H, if you want to jot it down, which basically indicates that it's the responsibility of the holder, the franchise holder, to get the signal from the point of origination to the head end. And I bring this up only because I've gotten 2 or 3 calls over the last 6 or 8 months from people, particularly in Southern California, who've encountered Charter coming in and saying, you have to pay. And in fact, in one case, there's a monthly charge. It's not just the initial setup. There is a monthly charge that's being charged. So please be aware you have rights under DIVCA with regard to that issue. I won't go any deeper in it because it's pretty clear it's not an issue for anybody in the room. But I just, if you hear of folks that are being told that, you should be aware that they shouldn't be charging. I mean, again, the language isn't perfect.
It's pretty close to perfect.
Pretty good on that.
Though, as I recall, it doesn't set minimum standards for the capacity of the system.
Right, and so that's just another thing that as we look at the sort of whole peg channel functionality and et cetera, that has come up. And now, I guess we'll move on to talking about the funding issues, because I think that's a lot of people have a lot of kind of questions and really want to dive into that. First of all, I just want to point out on that same sheet that I handed out on page 2, there's a whole set of bullet points on funding that I want to just know where's there. And also, there's a separate handout that's a table that deals with DIVCA, the Federal Cable Act, and this is on, for those of you who have your tablet or your laptop, this is on our website if you don't happen to have it, or if you want to download it at a later time, it's there.
What's it called?
This is called, the handout's called DIVCA versus Federal Communications Policy Act of '84, relationship of PEG funding to franchise fees. So let's dive into this one because it's complicated and it's not black and white. First of all, we need to talk about the relationship between, how do we want to start this, Gail? There's a lot of different ways to look at this. I mean, the confusion that I hear is from people is how can we use our PEG fees under DIVCA? That's the biggest one. And how does that relate to the franchise fees? Okay, that we get, that's our, in most cases, 5% of gross revenue. Okay, and then what can we use our DIVCA money for? And then I have another hand up there. Yeah.
There's an additional question,
Uh-huh.
and that is if you shift from franchise fees to your local community to state, how does that work? I mean, how do they divvy up the fees?
Good. Starting off, this is an easy one. The fees do not go to the state; they come to you. So they come to the local government. The franchise fees that local governments collect under DIVCA go to the local government. They do not go to the state and then get redistributed back to the local government. Okay, so, I'm glad that came up.
Yeah, and there's a really important point on that, like kind of a sub-point on that. Franchise fees and the PEG fees are slightly different under DIVCA in terms of the collection. You will collect them, but you don't have to take any action to be entitled to get your franchise fees. But if you want to collect a PEG fee under DIVCA, you have to enact an ordinance to collect it. So that's the, and we'll talk about Prop 26 in a minute to try and muddy that water, but that's the most important thing you have to remember in terms of one of the really important reasons why you need to pass a DIVCA ordinance is because you will not get PEG fees. They may accidentally continue to pay you, but in theory they could just stop because you haven't enacted an ordinance requesting a PEG fee. On the state level, or on this kind of difference between peg fees and franchise fees, I think one general comment I think that's good to bear in mind that people get a little bit mixed up about how they interrelate. I always think of it this way: the franchise fees, there is a federal cap, and there is also in the state law 5%, right? So that's what you can pay. That's what you can collect in franchise fees. You can collect peg fees in addition to that will not be credited as franchise fees as long as they are spent on capital. If you spend something that you've called a peg fee on something other than capital, then the risk is that that the operator will say, well, you know what, that's really a franchise fee. It goes towards our 5% franchise fee cap. So that's if you're an access provider and you're thinking about your budget and how you're going to spend your budget, that's the risk that you're taking is not that they're going to say, give us that money back. They're going to say, you're now spending it. It's now become, now it falls under a franchise fee kind of category. We're going to assume we can have a credit against the franchise fees that we're paying to the local government.
And let me just start,
You don't want to do that.
let's kind of roll down this one, because if you look at this table, and I want you to look at the column on the left, I think most everybody has a copy of the table, okay? What I've done is quoted, just put right into the language from 5870N of DIVCA. And there's a reason why I'm pointing this out. Fred and myself and a number of other folks were kind of involved through the good graces of Senator Simitian's office and Senator Peralta at that time. We got to get into the back room in the early summer of 2006 when the horrible assembly bill was taken over. And through the good graces of an attorney who was with Miller and Van Eaton and a man named Bill Lowry, we offered up a lot of changes to try to fix what the assembly language looked like. Frankly, a lot of that stuff got in. Not everything, but a lot of that stuff got in. And in some cases it got in pretty much the way we wanted it. In other cases it didn't get in at all, but in other cases they tweaked it a little bit, okay? And herein lies one of the tweaks, okay? The thing, if you look at the staff report from the assembly staff that was written after DIVCA was passed, and that report is still up and available, you will find in numerous sections of that report, when we talk about the PEG fees, the term PEG operations used over and over and over again. It doesn't say PEG capital, it says PEG operations. Now, if you look at section 5870N, and I'm going to read it to you, and so most of you have it in front of me, I'm going to lay out where I believe that there is really potentially several readings of all of this, okay? And why we're seeing different approaches by local governments and how they are dealing, and PEGs, and how they are dealing with using their PEG fees. And it starts out, a local government may by ordinance, remember what Gail said, okay, establish a fee to support PEG facilities consistent with federal law. If no such fee exists, in other words, you weren't getting anything before. You weren't getting 5 cents or 20 cents or $1 or anything, okay? If no such fee exists, the local government may establish the fee at any time. The fee shall not exceed 1% of the holder's gross revenues. Notwithstanding this limitation, if on December 31st, 2006, a local government is imposing a separate fee to support PEG channel facilities, doesn't say capital, it says facilities, that is in excess of 1%, the local government may, by ordinance, establish a fee no greater than that separate fee, and in no event greater than 3% to support PEG activities. Okay? So we've got a staff report that maybe they were sloppy with their language and they used paid operations all over. But if you look at the staff report, there are no less than 10 places in that staff report that talks about paid operations. We've got language here that is not, in my mind, black and white at all. It's gray, it's badly written, okay? That seems to establish two categories of paid fee uses. One that relates to those entities that had no fee, and one that relates to those entities that had a fee before. This ties back to a phrase called do no harm, which was being talked over and over and over again during testimony during the summer of 2006 when there were hearings with regard to pay. And that we heard over and over again, we do not want to do harm to those places that have things in their franchises which they have duly negotiated over a period of time. We do not, the sense was they shouldn't lose something they already have. And losing the ability to use the money in a manner that was already in place in a franchise, be it because of settlement from something that happened 15 years ago, for whatever reason, they could, under federal law, and did negotiate support for pay that was not limited to capital and that was over and above the 5%. So I bring this up only because I don't think it's 100% black and white. I think that it is subject to interpretation, but the issue really becomes, do you want to take the risk? Okay? At the end of the day, do you want to take the risk? And are they going to send the cable cops after you if you do? But at the end of the day, they still have to pay the 1% or the 2% or the 3% or the 1.4%, whatever it was you had before, anyway. And so I bring, and I've got bullet points in this outline, but I want to bring this up because it really is not, I mean, I have some cities who literally shut their operations down because they were so concerned about, and then you get the whole issue of what is capital, which we will be taking up here shortly. But I wanted to throw this out right out front because it really is, to a certain degree, the elephant in the room for some folks.
It really is a risk tolerance question more so than a legal question. I think there's a question right there.
Yeah, and I apologize if I'm asking this from a very ignorant standpoint because I'm not sure I know enough, certainly as you guys do up there. If I understand correctly, franchise fees can be used for either operations or capital expenditures, but we're talking here about the PEG fees, which in some cases we believe is limited just to capital. You may be able to get away with it, correct?
Correct.
The franchise fees can be general fund, any purpose.
Right.
Well, that was my next question.
Yeah.
So the cities can use the franchise fees for anything they want.
Right, yeah. Franchise
Whereas
fees
the
go in
PEG
the
funds are committed to PEG specifically. A last question on this point. Is this entire act focused on cable providers, i.e. are companies like DISH completely exempted from this? Is there political pressure or competitive pressure, let's say, by the various providers to actually try to create new legislation that may be encompassing all?
This legislation is intended to address entities that provide video service by using the rights of way, the public rights of way. And so that's why the satellite operators, this is not their area. They don't use the rights of way, so that's the focus of that. Fundamentally, getting a DIVCA franchise is getting an authorization to use the public rights of way to build your system. We tend to say cable operators, but because that is, you know, the common kind of parlance, but in actual fact, AT&T, who likes to always be a little different, claims that it's not a cable operator. But it is a video service provider under this statute.
And the rights of way are key going back to where this all began. And the idea being that these operators use the streets and rights of way to deliver service. They're using the public's property, and the public should be entitled to something in return. And all this dance is to calibrate what the public should be getting in return for the use of the streets and rights of way.
I want to leap over because both Fred and Annie are in situations that are our state franchises now and that had paid fees that could be used for multiple purposes before, and I want you guys to share kind of how you guys handle that from a government perspective.
There's about 90 answers to that question, so let me just give you some bits and pieces. In terms of AMP's relationship with the city of Monterey, it really is a non-issue because of the amount of money Monterey puts into AMP's hands. It can easily, it's an accounting exercise to make sure the PEG fees go to capital kinds of things, and the other money goes to operating, but Monterey sends AMP 32% of its franchise fees for PEG operations. So with Monterey, it's not an issue. It becomes more of an issue with some of the neighboring communities, and again, we get into the risk tolerance part. With a couple of our communities, it remains not an issue, and the community is willing to take the risk. A couple of partners are looking at this language very, very rigidly and are concerned about using the money for a non-capital purpose. Again, in AMP's case, it's not that big of a deal because there's enough unrestricted money coming in to take care of things. It's getting a little bit tight, but so far it hasn't been a big issue. But certainly if AMP scales out further and we start working with additional communities and they take that more rigid view, the risk-averse view, it could be a serious concern. But at this point, up to this point, we've been mindful of it. We're careful in our accounting. We have some, ground rules in terms of what is defined as a capital expense, and we'll talk about that, I know, in a few minutes. But it hasn't been that big of an issue for us yet. It really comes into play when we're working with a new community and working with their legal counsel to say, this is what we think you can do, and bringing that discussion to a conclusion.
Could you, so folks know,
Well, what are you telling them you think they can do?
I want him to explain to you how much money they're getting on paid fees, and if you mentioned the percentage of franchise fees, because that comes into play in their situation. Your paid fees are 1 point?
No, it's 2.49%.
Something
like that. Thank you.
2.49% of gross is paid fee on top of the 32%.
And that's also interesting because in the old local franchise, the fees were per capita. But now as rates grow and grow and grow and penetration grows a little bit, that percent of gross becomes a better deal for us. Also, none of the operators have expressed any interest in looking at that with us, and we know that possibility always exists, but there have been no implied or veiled threats or anything along those lines that has caused us to be concerned at this moment.
And you're right, you had a question, I'm sorry.
Yes. Well, you said you were talking to communities that are just coming in and how risk averse they are to using PEG fees. What are you telling them that your position is on that?
We default to federal law, which is open, and again, our enterprise is structured such that we've got plenty of capital needs that need to be attended to, and we're not that stressed for operating funds just yet, so it's not that big of a conflict. We try to encourage an open-minded, risk-tolerant approach, but if we don't get it, we have ways of working around that. We're big enough, fortunately, where we're able to do that.
Annie, do you want to share with us the Palo Mid-Peninsula experience?
In Palo Alto, our local franchise, thanks to our very wise JPA partner, negotiated an 88 cents per subscriber pass-through fee. And in the local franchise, the language said that fee could be used for any PEG purpose. And in the process of negotiating that summer in 2006 in Sacramento, one of the things that we got grandfathered into the law was the carrying forward these pass-through fees. So we have been telling ourselves that because our local franchise allowed us to spend that 88 cents per subscriber for operations, we would continue to do so until challenged otherwise, and that's exactly what we've been doing. We also have a capital fund of our own that funds our capital purchases. So, and we're very, very lucky that we have that. And we, you know, so if, and as far as I know, this has not been challenged anywhere in California, and so we're hoping that that continues, but it would be, you know, a painful experience to have to figure out how good, it's essentially about $327,000 annually now that we get in peg fees as a result of this pass-through fee, that we'd be hard-pressed to say it was being spent on capital expenditures each year.
When does that agreement expire?
They're under a state franchise now.
Yeah.
They're under.
So the 88 cents per head remains in perpetuity?
Yes.
Yeah. I mean, and that was really that back us up a step for a few people in the room. At the DIVCA, the intention of DIVCA is if you had money, and both of these groups of communities did, in their local franchise, that could be used for paid purpose, that money wouldn't go away when it rolled over from a local franchise to a state franchise. Now, there is language that directs us to translate that for purposes of balancing between the incumbent and any new provider into a methodology that will make it consistent between the two. So in the case of Monterey, for instance, in a number of places, when they had like $1.25 a subscriber a month or some amount, you take that, you look at what the franchise fees were at the end of, on December 2006, you determine what percentage of the gross revenue that was at that point in time, and then when you passed your DIVCA ordinance, you put that percentage in. So that it's the same whether it's AT&T or Verizon or Comcast or whatever your providers are, they're each obligated to exactly the level playing field of the same amount of dollars and cents between the two operators. So that's a sort of mathematical part that has to occur in a case where you've got, and in some cities it just said it's 88 cents, it's 88 cents for both subscribers, or it's 50 cents, it's 50 cents, excuse me, for most companies.
And I skipped a step in my explanation. We have the same grandfathering opportunity that Annie described, and because Monterey is so much bigger than the neighboring jurisdictions, we're able, it's an accounting exercise, but we're able to move money around such that we're not faced with those kinds of challenges. And Lord knows we've got capital needs that money can go to when it is restricted.
So does this change if the provider changes?
No.
No, when AT&T came on, they had to pay the 88 cents as well to us.
Yeah, there are a couple of provisions, they're less than clear on how this transition was supposed to work, but there was basically kind of two stages, or you could be in two categories. You could be in a category where no one was paying a peg fee, right? And then you could establish a peg fee of 1%. Or you could, or say they were paying something, but it was very low, it was less than 1%. You could establish 1%. So 1% became the floor. There is also a ceiling, and that is, I think it's 3%, right? And so an 88-cent amount, you must have determined at some point was less than 3%, it was okay. So you could carry that forward. I think the more common approach that I've seen in ordinance is actually to translate that into a percent, as opposed to using a number like that may, going forward. There was also, so that would be what you would establish for everyone to pay going forward, but there was this interim period potentially where you had a cable operator, an existing cable operator, this is how they imagined it. It was an existing cable operator, they're paying some amount. A DIVCA franchised operator comes in, and what amount should they be paying? Do they match? Do they pay? No, they had this kind of pro rata language in there that said, okay, well, if you have some existing obligations still to pay, cash payments, then they should be pro rata, split up among the providers based on how many subscribers, and you collect information from the providers, but how many, I haven't heard of any community that actually tried to do that. They just said, okay, we're just going to figure out what it is as of the end of 2006, convert that to 1%, and charge every DIVCA provider that amount of pay.
And your DIVCA ordinance lays out the rules of the road for that, and that's why
Yeah.
one of the reasons why that ordinance is so important.
So if you're under a local franchise and you have not switched yet, they just continue to pay under that franchise, whatever they're paying, or if they're not paying anything, then they don't pay anything. And your first opportunity to start collecting is when they switch to a DIVCA ordinance, when they switch to a DIVCA franchise, and you establish your peg fee.
So just to be clear,
There's a whole bunch of.
I had a
Here,
question.
go.
I had a question that started with you, Gail, but Fred complicated it.
I'm really good at that.
You said that the pay fees, if they're challenged by the provider, they would withdraw that or apply it to the 5%.
They may say, actually, this is being spent, this is not being spent on capital, so I'm gonna take a credit on your.
So the pay fees then, what happens to them? And when Fred says it's an accounting exercise, that the capital can be used by the city and the pay can be paid out of that's what I need to understand. How does that work, that accounting exercise of taking, is it paid capital only or capital?
Yeah, I think I did confuse things. The franchise fees go straight to the city. It's essentially, people don't like when I say this, but it's a form of rent for the public right of way. The PEG fees end up with the cable, with the community media organization through this dance, and it's those PEG fees that are subject to this interpretation. The accounting I described is with the community media organization. The issue that Gail's talking about is if the community media organization uses a PEG fee for operating and the cable operator wants to push it, they will ding a like amount from that franchise fee going to the city. So the community media organization accounts for how the money comes in. This is restricted, this isn't, from all these different sources. In theory, as you expense money, as you spend it, you're saying, well, this fits the definition of capital, so I can match this money to that. This is operating, so I've got to use that money. It's just different flavors of money. But if the cable operator says you're using the money wrong, the community media organization isn't the one that's directly penalized, it's the local government. And like I said, you tend to not want to do that.
And to the best of my knowledge, since DIVCA passed, I don't know of any place in the state where the operator is actually carried through and digged inside.
No, and they I mean, they're.
And there are any one of a number of places that frankly are doing what you're hearing described up here, which are essentially, we had the right to use it for all paid purposes under a local franchise because they had more than 1%, and they fall under that notwithstanding this limitation clause that I read to you, okay? And this is the issue of how risk averse you are.
Yeah. You know,
and they have, I was just going to say, that they have deemed franchise fees for other reasons. For example, the PUC, since they're now the franchise authority, they had some staff doing, I would like to say, just rubber stamping things, so they have a budget and they charge a regulatory fee to the state franchise holders, and they have taken it upon themselves to credit that against their franchise fees.
But on the paid piece, there's threats been made from time to time, but I don't know of any place where they've actually carried through with that threat.
Wasn't there a case against the city of Glendale recently?
That's not related to pay fees at all. That's a paid channel and paid an INET issue. I don't believe there's no. I was an expert witness in that case. I don't recall that it had to do with paid fees.
You know, for us, for AMP, the issue.
Okay.
No, I have a question.
For AMP, the issue, we have an ongoing, completely different issue because of the 1% ceiling versus communities that are grandfathered to a higher level. AMP serves 4 or 5 cities right now. A couple of the cities, 2 of them are grandfathered at something higher than the 1%. They're both in the 2s. But some of the other communities are 1. From AMP's perspective, we're trying to serve these cities in an equitable way, but some cities are paying a lot more than others, and therefore subsidize, you got city A subsidizing city B. We spend a lot of time trying to rationalize that in terms of service levels, but it is a real challenge for us, and that, for us, is a far more challenging thing than the reconciliation of the capital and operating.
This gentleman here.
Okay, just kind of back up slightly. So we get 40 cents per subscriber. We're switching over to Cougar facilities. The grandfathering part, does the function change? Our 40 cents goes for operations. You're saying then it's grandfathered over, and what we're hearing now is we're going to get 1%, which is actually more than 40. But so you can't grandfather the 40 cents per subscriber in and then use it for operations. The definition for use changes.
Well, Sue's interpretation has never been challenged in a court, or right? And so you have, the basic overlay is that federal law, and it does, you know, the peg fee is established in accordance with federal law, and then we have this other language. So that threat of, if you're spending on something other than capital, that it might get a, you know, operator might someday say, I'm going to apply this to the franchise fee, is there regardless of DIVCA. DIVCA didn't change anything on that level. It just gives us more language to try and parse and figure out what
So the ordinance can't say we want that similar level.
Well,
and that is used for operations.
well, the other thing that I mentioned when you were talking is that there is, I believe there is language in the cable that talk, were one of the FCC orders or something on this. An operator can always voluntarily pay you money to do anything, right? And so the question is whether you have a voluntary agreement to do that.
Well, it's sort of like,
an
an interesting analogy that it was with the city attorney yesterday, and we were actually negotiating a franchise, and the cable operator says it's illegal for us, and this is a state we don't negotiate, okay? Which means, and we'll get to the CPUC renewal stuff in a minute, which means if the parties agree that you can use your money for operations, and that's the case we had both in Monterey and in Palo Alto, under oath, you could. So she says, okay, so I have 2 horses. If you steal my horse, that's illegal. But if I say, you can have my horse, I'm giving you my horse, that's not illegal. And essentially, the point that she was making to the cable operator was they were saying that any amount of money over above the 5% that was not spent on capital, and that even was including things like complimentary cable drops, all had to come out of the 5%. Because any amount of anything, you know, pursuant to under their interpretation of things, over and above the 5%, you couldn't even an informal negotiating process, as it was done in many places in California, and still continues to be worked out a deal where you had paid money for operations. So, I mean, that's sort of a side issue to this, but it kind of weaves into this issue of why there are some places in the state, like these two, that had money for PAG that could be used for any PAG-related purpose. Let's keep it broad and not talk operations activities, any PAG-related purpose. So what happens to that when you roll over to a state franchise? And that's the core of what this conversation really is all about. Now, we need to talk about what is capital. Okay, but I am told that there are treats and coffee outside.
Coffee hasn't been refilled yet.
Okay, so I was told at 3, and I didn't want you all to sort of die of hunger and thirst. So we could, if somebody could just watch with the cup, we can take a break now if you want to, or we can just keep going. You tell me what your preference is. Keep going. I'm hearing. Keep going. Keep going. Okay. But now we're going to go to capital. Oh, what's that?
Just a quick question.
Sure.
I think I know the answer to this already. So if you have a local franchise and you have a subscriber pass-through fee for pay, and it does specify that it's used for capital purchase costs only, when you do transfer over to DIVCA, I'm assuming that you can change that to any type of pay-related cost?
No, so sometimes what happens is you will see
Sorry, could you repeat what you said?
Oh, okay. He was asking if you have a local franchise that says you get a PAG fee of X dollars per subscriber or whatever it is, and it says to be used for capital purposes. It says that right in the franchise. the question was, if you roll over to a DIVCA franchise, does that mean now you can do something different? As I said before, this is principally an issue of federal law in terms of the restrictions. So, but what you see sometimes in franchises is they will put a restriction on the use that is even tighter than federal law. So then it becomes like a contract restriction, right? Because a franchise is also a contract when you have your local franchise. So they may have put, I've seen franchises where they put very, you have a peg fee that you can use for very limited purposes that are maybe a subset of capital expenses, right? And that would be, so if in that sense, if it's really limited, then maybe you have a little bit more flexibility in terms of what you can spend your money on now because of what might be capital as opposed to if it listed just, cameras and facilities and, something really limited, or buildings or whatever. So, but otherwise, basically, it doesn't, I don't want you to leave here with the impression that if you have a DIVCA franchise, go spend all your money on operations.
Right.
Don't do that. It's a federal law restriction. There is some question of interpretation under state law, but it's still, the basic risk is the same, even though we haven't seen any operators do anything in terms of trying to ding your franchise fees. That's ultimately the risk that you're taking. So the DIVCA franchise is not making that radical of a change.
If the operator, we have enacted a 1% PEG fee. We have an agreement that was enacted right before DIVCA became effective, so we've said it's not subject to DIVCA, but then in addition, we adopted some ordinances that adopt DIVCA, so we've got this crazy scenario. But the operator is passing the 1% directly to the subscribers, so it's not costing them anything. Does that still count as a PEG fee?
Yeah.
Okay.
And they pass through the franchise fees too.
Right. I mean, and just so we're clear, federal law permits cable operators to show a line item on the bill, okay, for the pay fee and the franchise fee. Now, in a few cases, I've actually known operators who chose, it's their choice, have chosen not to show the pay fee or not to show all of the pay fee, okay? But they always, I don't know any place they haven't shown the franchise fee.
Right.
But you really have to separate the issue of the ability to show it as a line item on the bill from some of the other things we're talking about, because they really are sort of independent when you get right down to it. Here and here, and then we'll go to capital.
Sure, actually, mine was more related to capital, but in the film industry and video industry, they have procedures for capitalizing the costs of the end product that's delivered. That all production costs become capitalized costs. Public works projects have accounting procedures for capitalizing costs. Software industry, even the cable company itself, have procedures for capitalizing costs. So has anybody tested these waters, arguing that the product put out over the cable system can therefore be capitalized?
You took us right into the what is capital discussion. I want to make sure if this gentleman's question is okay. All right.
So on this issue of the risk of utilizing PEG fees for operations, what I'm hearing you say is there's no legal precedent one way or the other, and there's no attempt by any of the providers to actually take back through franchise fees, although they potentially have the ability to do that. That's what I'm hearing so far?
Just a lot of chest pounding.
So the position is you either take the risk or you don't, and you hope that somebody else might be the test case for
No, I think the position is you manage the risk using some of the things we'll be talking about in a few minutes.
Yeah. And that takes us right to the issue of what is capital. Okay. And I think you set it up. There is not a black and white definition of what is capital. Okay. And for those of you who work for local governments, you know that depending on the project you're working on or whatever, the definition of what is capital under that project or this bond project or whether it varies, okay? There's also the issue of, you know, the issue of depreciation. There's the issue of certain items that cost more than $500 then are considered capital excess. So you have all of these factors that come into play when we talk about what is capital, okay? And so I bring it up only because this comes into this whole dialogue and exactly what Fred was talking about and what you brought up as that there isn't a black and white definition of what is capital. It is not building a building only. It is not necessarily buying a piece of equipment. What I've seen frequently used is sort of a middle ground, but there are probably the other folks, and I'm going to have everybody else kind of dive into this one, is equipment, purchasing the maintenance of that equipment, the safeguarding of that equipment, in other words, the ensuring, the safeguarding of the equipment, the maintenance of the equipment or facilities, those are fairly safe items. So it's not just buying a piece of equipment, okay? It's maintaining that piece of equipment. It's insuring that piece of equipment, etc. Now, I think that's a really fair, even in a rather conservative environment, a safe zone, okay? But there's some interpretations that go far beyond that, and that there's clear municipal and local government justification for those things go way beyond that. And I'm going to be quiet and turn it over to Fred and Gail and to maybe respond a little bit to what she's talking about.
You have to do this day to day.
Yeah, and let's remember, it's probably a good opportunity to reflect. This legislation is lousy public policy that is really poorly written. And what we're trying to do is figure out ways to get there from here with that legislation as a backdrop. I mean, there are no certainties here, and it really is about managing risk. One of the things we've discovered along the way is that the classic accounting definitions of what is capital and what is operating is not, you don't necessarily need to use that in this environment, and the cable operators are typically okay with that. You know, when a city buys a tractor, that's capital. When the city applies a mechanic to that tractor to change the oil, that's operating. That's fine in that framework, but we have opportunities on the community media side to look at things a little bit differently. Your facility insurance, your facility utilities, your facility maintenance costs, and the maintenance costs for those equipment. I've even heard of examples where time spent programming your playback servers is equipment related because you're touching equipment. You know, I don't know. I don't know where that line is. In AMP's case, many years ago, we worked with our accountant who has a lot of community media organizations as a client to define what is within bounds and what isn't. And we spent time with the cities as well. It was easy in Monterey's case because I was wearing two hats, but we spent time with the cities as well, sort of vetting those interpretations and pointing to some sort of documentation or legislation or regulatory authority somewhere that supported the interpretation. And you know, we went down the merry path, but the traditional accounting definitions of capital and operating are useless here. You need to think about your business processes, your tools, your facilities, and what legitimately can be charged off as a capital-related expense, and then anything that isn't capital goes into that operating ad. And I don't know how to be more precise about that without spending hours talking about it here, but that's kind of how we did it.
The point that you brought up, which is a good one, is that there is actually and there may be people in the room who are accountants, but there is a entity that puts forth these tomes that guide CPAs in certain areas. And there was a CPA who spoke at an ACM conference several years ago, who spoke to exactly the point that was made earlier, which there is a principle, there is a guidance for CPAs who are working in the film and video industry, which talk about capitalizing production costs. Now, in fact, those are typically in an arena where there will be a product that will ultimately be sold, and that product will generate revenue, okay? But this CPA spoke specifically to that and related it to this field. That goes back to what Fred's talking about, where that there isn't a black and white, this is this, and this is this, and this is this, and you have to really look at your business practices, understand whether you're a local government who's dealing with a nonprofit, or whether you're the nonprofit, or both. Look at how you want to relate to how you're going to use these dollars, and create a set of policies, okay, which will talk about how you use and how you track those dollars. So that's a sort of the capital operating dilemma. One or two more quick little points on it, and then we're going to go to the AG's upcoming opinion, which hasn't been issued yet, right? The last I heard it hadn't been issued. Is that there are some very creative ways of doing things that have been evolving, which are fascinating. I will take what's happened in the city of Fresno as an example with regard to the community media center there and their funding. And I have the executive director sitting in the back of the room, so tell me if I say this wrong, okay? Essentially, there are several different documents that define the relationship between the funding received by the community media center and the funding provided by the cities of Clovis and Fresno to the community media center. There's a master agreement that passes the 1% franchise fee over to the nonprofit to provide services. Interestingly enough, the city had the nonprofit when it was set up, and this is all post-2000, this is all post-2006. So this is all in an environment where everybody was under DIVCA from the get-go. There was not a nonprofit operating media center in place before the passage of DIVCA. The city the nonprofit needed a space. The city had a space that was sitting open in downtown Fresno that they really wanted to get somebody in. It had been an art museum. So we're going, there's about $700,000 that 1% translates to. It's moving over. Okay, and there's an empty space and we need a space. And there's certain services that the city might want to sit in one that's in addition to the baseline services that are in the base contract. So essentially, the nonprofit pays some of the DIVCA money back to the city to rent the space that is now the city's got a tenant in there. It's in an area they want to get developed. They want to have some solidity around that area right off downtown. The city takes part of that money that's properly spent for capital back and enters into a separate agreement with the nonprofit for certain services. Okay? Very creative. It follows a very traditional, legitimate definition of what is capital. Okay? And so this may not be a fix for everybody, but it was a real creative way of dealing with and then that money that comes back over, of course, that's just general fund money. That's not limited money, okay? So you've got this flow of money back to the nonprofit for these additional services, okay? And that's general fund money. So there's a lot of permutations, and that's just another way of looking at this sort of capital, this conundrum. And I have this hand in the back, yeah.
I just had a question about what you're describing sounds a little bit similar to what happened in Glendale and the lawsuit there that basically accused the municipality of money laundering. So can you describe how the Fresno model isn't doing that? Because I think that's a real concern, that we don't want to fall under the same parameters that Glendale fell under. We don't want to invite a lawsuit in that particular way.
I don't know all of the details in Glendale. I was an expert witness on that case, but not that part of that case, okay? I feel very secure knowing the conservative nature of the city attorney's office in the city of Fresno, that if they're, and I know the gentleman who is the attorney there, Bob's still there, right? Bob Coyle, who and has been with the city for a long time, that if there was any risk that was associated with this, that Bob would not have approved this particular approach. Okay, I worked with Bob when we tried to get a franchise negotiated down there before DIVCA kicked in, and we were around 98% there, and then DIVCA kicked in and threw away 2.5 years worth of work. So I worked with it pretty closely. So I wish I could get into the details of Glendale. I don't know that piece of it, but I do know that I feel very confident that if there had been any question whatsoever, the city of Fresno would have never signed off on that approach. In fact, they sort of, there was a kind of, light bulb went off kind of thing between both the city and the nonprofit about doing this approach. So that's what I can tell you. I don't know the details, and you don't know the details of that.
No, I don't either. I'd be curious to know.
Well, as far as I recall, what happened in Glendale was that the city basically charged themselves, they calculated the square footage of their building that was being used for paid programming, and they calculated the capital cost, the percentage of the building that it cost to build it, and then they charged themselves, and they used to, they transferred the paid fees, pay money into the general fund.
So the key difference is in Fresno, there is a totally separate 501c3 nonprofit organization. There's a totally separate business relationship with a non-city entity. And that's the real key difference. Thank you. That's very helpful. I think now we'll go to AG's. Some of you have probably heard about this, and I'll turn it to Gail.
I have just question on capital equipment. What if you purchase equipment that's not solely used for paid programming? Is there an issue here?
There can be, and AMP tries to account for that, and if we use equipment for a non-PEG purpose, generally that's on a fee basis, and that comes in to offset a piece of that. There's a legal problem. There's also a bit of a moral issue there as well. You get this money in from the cable operator to provide PEG services back to them. If you're using that equipment for a custom shoot for another client, there needs to be some sort of reimbursement there, and that needs to be built into the accounting system.
Yeah.
Okay, so what,
AG.
chapter 26 and 8, so if paid fees weren't complicated enough yet, we have another rule, and that is a county.
Skip, you must speak up. They're not hearing you.
Sorry. That is a county, and I cannot remember the name of the county now.
Lake County.
Lake County, that's it. Okay, so they're one of the, there are a lot of jurisdictions out there that didn't get a DIVCA, didn't get AT&T or Verizon show up, and they're just all rolling over. They stay on they're on their local franchise until it expires, and then that's when they're rolling over, right? So this is the situation in Lake County with, I think the provider is Mediacom, right?
Yes.
Yeah. And so Mediacom said to them, created enough controversy with them that they felt that they should ask the AG's office for an opinion. And the opinion that they've requested is on whether a Prop 26 voter approval is required before you can adopt a PEG fee. And so this came up, I think it was brewing for several years, but it came up actually over the summer. The AG issued a letter inviting comments. I have the contact information if you want. There's still time to provide comments. The way they do this is the AG's office has a question, they put it out there, say, we're going to answer this question, give our opinion. We would like comments by such and such a date, but we will accept them at any time. So they're still open for comments. I've contacted them earlier this week to find out when they expect to have their opinion issued, and they said they've got a big backlog and it'll be months. So there's plenty of time to still comment. I will tell you who has commented. We filed a letter on behalf of some communities, the City of Ontario, Los Angeles County, and the Sacramento Metropolitan Cable Television Commission. So we filed saying, no, Prop 26 does not apply. Sonoma County filed saying, no, it doesn't apply. The League of California Cities filed saying, no, it doesn't apply. And the Jarvis Taxpayers Association said a lot of things.
Yeah.
I think they said it applies, but I'm not entirely sure, because then they kind of said some other things at the end. It wasn't entirely, it was clear that they were not in the PEG world, but they don't like taxes. So that's where it stands. The issue is really whether what creates this question about whether a PEG fee may be a tax subject to Prop 26 approval of the voters is because everything is a tax subject to Prop 26 approval of the voters, unless you fall into one of the exceptions. And so the exception that we mostly focused on, and which is clearly an exception that applies to franchise fees, is that it's a fee being paid for use of public property. And the tricky part about PEG fees is there's some language in DIVCA that talks about the franchise fee being rent, and then there's the PEG fees, and so they're kind of out there, and well, what are they really? Are they rent, or are they not rent? Is it for use? But it's a condition, basically the PEG fee is a condition of your franchise grant, and so it is effectively for use of property, at least that's what we've been arguing to the AG's office. So if you are interested in also commenting on this issue, there is time. I can give you the contact information. It's very simple, very open process. You basically write a letter and you email it to them. It's that complicated. And if you want to see any of the submissions that I've made already, I can send them to you, or you can also just email them and ask them to send them to you. And what will happen at the end of the day is we will get an opinion. It's non-binding, but it is, it's going to be waived, especially if it's a bad one for the PEG fees. It's going to be waived by the cable operators in your communities.
I have a couple in there.
Yeah, just to clarify the question. I know we're concerned about the PEG fees and our franchise fees and such, but what does DIVCA open up opportunities for other revenue or financing? What other revenue opportunities does DIVCA open up?
Oh, was that the advertising question?
I'm not sure where you're going to elaborate a little bit on your question. What, for example?
Sponsorships.
Okay.
Things such as that.
The question is, does DIVCA open up the opportunities for other revenues? And this goes to the issue of language in DIVCA, which essentially seems to imply that you could have advertising, okay, on access channels, etc. I guess, to me, there's actually a little bit of a tension, again, between, on this, in DIVCA, and it's not a bad it's not bad or good, it's just a tension, okay? And that is, there's nothing that's ever prohibited community media centers and paid access operations from generating revenue over and above support that comes from the local government or from a grant or whatever. And more what we're seeing today is fee-for-services, production services, partnering with local community groups and organizations to provide services for them, producing videos that they put on their websites. The list goes on and on and on. So that opportunity, it has always been there. Going out and underwriting the football game of the week by local sponsors. That's always been there. DIVCA really hasn't changed that at all. It's just how entrepreneurial are you in looking at opportunities in the community to provide a service that's needed and to generate revenue to go back into the pot, so to speak, to support your community access activities.
And I would argue, in fact, that to survive in the post-DIVCA era, you've got to do just those things. I mean, the reality is DIVCA shrinks the traditional sources of revenue that community media's enjoy. If community media wants to be as robust as it historically has been, you got to think of other ways to bring money in. And I think there's some other sessions at the conference that'll be talking about that. So DIVCA doesn't really speak to it, but by default, we're there.
There was a reference to a one-minute rule. A gentleman up in the front said, could you discuss the 1 minute rule? I think that had to do with sponsorships.
No, I think that was a reference to one line in DIVCA that says PEG stations have to be non-commercial, but notwithstanding that, in essence, you can't have advertising, sponsorship, or underwriting. So I think the question was.
And that's what the tug and pull I talked about.
As long as it doesn't have any price in it, right? Can
They
have a
call
cost
to
or-
action.
Yeah.
Inducement to
Or
buy
endorsement
or
to buy.
call to
Right,
action.
the call to action
Yeah.
rule.
Yeah, I've got the citation right here. It says PEG channels shall be used only for non-commercial purposes. However, advertising, underwriting, or sponsorship recognition may be carried on the channels for the purpose of funding PEG-related activities.
Can you give the number or do you?
Yeah, it's 5870B. Now that assumes that some advertiser would be interested in our micro audience.
Jim, did you finish this?
I think one possible problem if you do real advertising is if you wind up losing your 501c3 status as a nonprofit. I've not seen that to be a problem with access centers. Generally, what access centers have adopted is they follow the PBS model of what is underwriting. That allows for a lot, and I've never seen that challenge, so you're safe if you follow the PBS model, which
Could you hear it?
pretty much
Step
everything
back?
except the
Just repeat what Jim Forward was saying is that one of the language may say advertising in DIVCA, that you do advertising, and the risk there, one additional risk would be that you're not non-commercial anymore, but also that you would put your nonprofit status at risk. And a PBS type model is probably what they were thinking of, or would be, the kind of thing, it would be like a safe harbor in terms of your approach to generating that kind of advertising revenue.
Yeah, still, and coming back to the AG's opinion, I want to muse about, whether taking this to the voters will result in these multi-million-dollar campaigns to try to suppress or excite support for PEG. But more to the point, is there what are your thoughts of how this approach balances or works in the universe in relation to what the state legislature did a few years ago, which was that utility user taxes had to go to the voters? Is there some rationale at play here?
Well, I think that I'm no expert in Prop 26, so kind of that reaches of what I know on it. But I think that the intention was, it's really was a tax, no new taxes kind of driver, right? And this is like being sideswiped by that. This is not, it just was not what was contemplated. It's, PEG fees under DIVCA just showed up independently and before, right, with this whole history under the Cable Act and local franchising, then along came Prop 26, and it just creates an opportunity to make a new argument against them. And that's, I think that's basically, I don't think it's more complicated than that. I think there were just two different tracks, right? There's this history and PEG fees, and then there's Prop 26 and no new taxes.
And Prop 26 is another example of poorly written language that is spending a lot of money trying to figure out what it means.
And just to maybe lay this piece a little bit more to rest, there's a big, long backstory on the Lake County situation, which I know, but I'm not going to get into it. If you're interested, I'll talk to you about it later. That sets a scene for why this request even came from the Lake County to the state.
So a question for Gail. You mentioned eliciting comment or support.
Is that something that you just sort of set it off the cuff and then we moved on, but is that something that we should all be jumping on top of and sending like, bundles and bundles of mail, or for, in support of the Lake County, situation, or when you said that, you said if anybody wants to comment, what were you?
Well, the comment period, the comment period is open.
It's open.
It's open until they issue the opinion. I think, the general sense I have is that more support is good. I mean, people understanding that they ultimately, it's written by the AG's office, it's written by attorneys that are just gonna, do their legal analysis. So the more that they're not gonna be sympathetic to, oh, please don't do this kind of letters, but if, me too, yes, rational, that's a rational argument, this is what it meant, kind of those sort of supporting letters I think would be helpful. And very interesting, you may have noticed I said who had commented, who has not commented, the industry, not even MediaCom.
My question is a follow-up to that, actually. I sort of heard two issues around that, and I just want to clarify, if we submit comments, what is the most important issue that we focus on? I think what I had heard was that it was a group of, and this is just, hearing it from our county folks, that it was a group of folks who were protesting or upset with the fact that a certain group was being asked to pay for something and everybody else wasn't. They're the only ones benefiting from that kind of issue. So more of the Henry Jarvis folks. Or is it an issue that the cable provider doesn't want to pay, they don't want to pass along the subscriber fee? What's the real core of the issue that when we submit comments, we should best try to address?
I think the core of the issue is take a look at some of the well-written responses that have already been filed and they're available by PDK, and look at what's in there and mirror it. Don't try to get into what the backstory is.
It's really a legal issue.
Some citizens group. And then for those of your attorneys in the room, you can write your own. I mean, their point is, for those who aren't, that's just a good way to look at it. Look at the league's filing or whatever.
Do you have any sense of where this could possibly go, or is it just sort of, we won't know until we know? I mean, do we have any idea scenario-wise what could happen?
Well, there are different ways they could parse this out, right? One is they could just say, no, Prop 26 doesn't apply. Best answer, right? Another is they could say, yes, it applies, but it applies only, Prop 26 only came in 2010, right? So you passed your ordinance in 2008, before Prop 20, you're safe, right? There's weird language, lots of it in DIVCA, but there's some strange language about the PEG fees and the ordinance that you adopt. There's some language in there, and I can read it for you if you want, but it's basically, they talk about it expiring and reauthorizing, right? And if you think about that, you're like, wait a minute, how does this possibly work? Did anyone pass a DIVCA ordinance that was with a PEG fee that was going to expire when the franchise expired? Well, which franchise, right? You might have multiple operators with different 10-year franchises. Well, what if they renew it? Did it not expire then? What happened, right? Oh, what about the guy who just showed up next week with their new, so there's some language that just wasn't really thought through, that is, to make it logical, you almost have to ignore it, right? You have to say, well, you don't have to reauthorize this expired. So, but you could have an opinion come out that says, oh yeah, you have to reauthorize, and so on the reauthorization, even if you came before, you passed your PEG fee ordinance, or your DIVCA ordinance before Prop 26 came into effect, when you reauthorize, you're going to need voter approval. Right? And then there's that other thing that we talked about, that period where you're supposed to share the franchise or the PEG fees. You have an existing obligation, and then you have the DIVCA provider, and you have the whole franchise, and that kind of pro rata sharing that's supposed to happen. Well, what about that? What does that? it's like bad language, confusion, taxes, no new taxes, and then they've got to interpret that and come up with something that's rational. So it will be interesting and to see what they come up with, and then it's non-binding. So it doesn't matter in the end. I mean, it matters because it's good to fight these things on every front you can, but in the end, yeah, no cable operators saying anything, no DIVCA holders saying anything, and if they choose to attack PEG fee because of Prop 26, they'll just go to court and do it. Or they'll stop paying or something like that.
So we have several other issues we need to get to, and we have 15 or 20 minutes left, and so I'm kind of going to give you a choice here, or we can just keep going and covering them all. The things we haven't talked about yet is institutional networks, and what happens with INETs when the local franchise expires and it rolls over to a state franchise, okay? Then we have the other I think, kind of key thing we haven't touched on is what's happening with the CPUC's rulemaking process with regard to the renewal of state franchises. In as much as we have some of those state franchises that are up for renewal and that will occur in 2014. So I kind of like to hit both of those a little bit, and then there's the enforcement stuff. We sort of touched on the enforcement stuff a little bit already. Does it make sense? Should we try to do a little bit of INET and then the rest on CPUC, or you're not interested in the INET piece?
No, I want to hear the INET piece. Anybody else?
I'm hearing INET. Okay. And is there anything else that we haven't talked about yet that we need to get in yet? Going? Huh?
Yeah, class action suit.
Going. Okay, so let me just kind of keep us rolling. So can somebody check and see if the coffee's out there now, if the refresh button's been hit?
Sue, if no one else wants to hear about INET, I'll just pick your brain later in the conference.
Yeah, I had a couple other people on the INET today. Okay, so can somebody tell me? I know some people are going to need coffee. I'm going to keep. I think we'll just keep going here if that's okay with everybody. And then if you want to slip out, and that's okay. But we're going to get an INET real quick, and then we'll go to CPUC. How's that sound?
Okay.
I think. Well, maybe we just need to take a break. Let's just keep going. Okay, INET. All right, this is a Libra talking. I'm sorry. A little this, a little that, trying to make everybody happy. Institutional networks. There have been actually a number of places that have gone through the transition from a local franchise to a state franchise that had an INET. There are two distinct situations. One is if the INET language is in your franchise. The second is if you have a separate standalone institutional network agreement with the cable operator. And they really do create sort of two different scenarios. Fred, you want to talk about Monterey?
Sure. 25 words or less. Monterey fell into the second kind of category that Sue just described. We have a separate INET agreement. Basically, when we did the renewal in the mid-1990s, when Sue and I were still in high school, we took everything that the cable operator was going to give us and put it into PEG. And we have an INET, but the city paid for the INET, knowing there was a good business case to build that INET. And the reason that worked is that we deployed the INET at the same time the operator did their subscriber system upgrade, and we just paid them the incremental cost for the additional fiber in the network, and it was very cheap. And we've got 40 locations in the city, and it's absolutely marvelous. But that's a network the city paid for, and was embodied in a separate agreement. And there's yet a third agreement that was liquidated damages settlement that said we were entitled to use that network for as long as it remained serviceable. So, and during the time where AB 2987 was being formulated and negotiated, we got some assurances from Comcast that those organizations that were similar to Monterey, their INETs would not be affected. They're trying to backtrack on some of that now, but that's a whole separate discussion. But we were pretty secure in that, and they've actually made some veiled threats towards Monterey, and my response is I'll go back to work for them, and they'll pull that fiber out of my cold bleeding hands. We're pretty confident that the network is going to remain at the city's disposal. We're aware of other situations where the network was in the franchise, not in a side agreement, paid for by the cable operator rather than by the franchising authority, where the cable operator giveth, and now the cable operator is saying they want to take it away and charge the agency for those services. And Sue's been spending a lot of time working with those customers. That case is a whole lot more challenging, and frankly, at the end of the day, the question will be, what's a fair amount to pay for that network access?
And another wrinkle on that is sometimes it's a combination. You know, if you had an INET in your franchise that said, in your local franchise, that said, they will build to these 10 sites, and if you want any additional sites, you pay for them, right? So then, the city's paid for some sites, or the county's paid for some sites, they've hooked up their 911 center, all these things. So it's kind of this mixture of we paid for some, you paid for some, and then they're saying, oh, and all of that is ours actually, and we would be happy to charge you a very high fee to provide that managed service. That's what a lot of communities are facing now that are just rolling off of their local franchises. And I can give you an example of one. I'm working with a few. I did not work with these people. This is the city of Watsonville. I don't know if anyone's here from Watsonville, but they just decided to build their own fiber network because they were faced with a charter franchise that's about to expire, and charter offered them 2 levels of service, their current level or their reduced level, and it said 20, so a fiber system, typical fiber will last 30, 40 years, something like that, right? So they said, okay, well, we'll give you a 20-year or agreement that over 20 years at our current level of service would cost you almost $3 million. And then the city looked at, well, how much would it cost us to build this system? Oh, under $500,000. So they opted to build their own system. But that's one of the, that is definitely, when we were talking at the beginning about some of the things that have lost under DIVCA, this is one.
And Palo Alto is another example.
Yeah, we do not have a separate agreement for our INET. It was negotiated in a round of local negotiations for renewal. And when we went to the state franchise, and when our existing local one ran out, Comcast was prepared to take away our dark fiber network. And then they wanted, their choice was to start charging us for a managed service network, which was going to be really expensive, not as fast. And when we took a look at it, they were actually going to be recharging each entity that was going to pay them. We've got 5 school districts that are using it in addition to the cities that are connected at the core. It was really a mess. And when we pointed out to them that they were charging multiple customers for the same link, and when we showed them after many meetings and years in making to get these meetings together, when they finally understood our typology, which was connecting the core cities, and when we said our JPA will pay for the core, and then you just charge the entities that are hanging off the core and not bill them for all the core links, we ended up kind of twisting their arms and getting them to give us, instead of the managed service bid, the bid for just providing that service, and they finally agreed to do that, and the amount was much lower than what we would have paid for the managed service, and it was better use of the existing facility. They wanted to take it back and make other uses of it, but we were trying to point out to them, who are you going to sell this link to the school to? You know, what customer is going to buy that? So anyway, it was a very protracted and nervous-making thing, because we didn't know what those estimates were going to be, but when they ended up finally coming in at a very reasonable amount, especially for the schools compared to what it would have cost them otherwise, it worked out to our favor.
In most, the examples you've heard, the Watsonville, that was charter, right?
Yep.
And then Monterey City and Palo Alto or Comcast. There's another charter example that I can share with you for those who might be interested, and that is Morgan Hill. And in Morgan Hill, there was an INET that connected both schools and city buildings together. And the franchise there rolled over to state in 2008, I believe. And frankly, the charter approached both the city and the school district, and the city kind of just didn't deal with it, and they kept using the INET and kept using the INET, and the charter never followed up and never followed up, and the school district sort of did follow up, and the school district ended up entering into a managed service agreement, a stark fiber that they had under the franchise agreement. In the meantime, finally the city charter started to send the city bills for the use of the INET. Now we're talking 2011, and the franchise expired in 2008. So what essentially evolved there was that the company, charter kept saying managed service, managed service, managed service. The city kept saying, no, we've got the dark fiber, and we're not asking for anything that's not already there. Well, what we figured, what evolved there was an identification of the fact that the charter had its hub site, which off its Master Head Inn in the Gilroy area, for the city of Morgan Hill, sitting on public property, and they'd never been paying any rent for it. Okay, and it wasn't easement. It was actually economic development property that had been acquired and was sitting there right next to an easement. And it wasn't like a big thing. It was like a concrete pad with framing around it, metal, and then some electronics sitting on it. But that was the hub for Morgan Hill. So what ended up happening there was a little bit of you've been using ours for 15 years and 20 years, and you haven't been paying us, and we really weren't aware of it. We probably should have been, but we weren't. And so it ended up that the city got its dark fiber. There's a dark fiber agreement with Charter to serve, and there's the city cable operator pays a certain amount per month to rent the space at city property, and then the cable operator pays to rent the city property, and the city pays a certain amount for the dark fiber, and it ended up being a deal that the city was comfortable with. From the standpoint of what the costs were going to be versus how much they're going to get. So, and that does, again, a very unique set of circumstances, but they didn't even, the whole issue of Charter's hub site sitting on city property never really evolved until we went over and started looking at it, and I'm like, okay, well, what is this? I mean, there's an easement here, and then there's a big bunch of land, and then there's a wall for this home development. Who owns this property? And then, oh, gee, it's city property. And then the light bulbs started to go off. So sometimes these INET things are very, very unique to certain circumstances.
And that's probably the moral of the story. Look for the opportunities that are available to you. Do you have something the operator wants? Do you have the opportunity to build your own at a reasonable cost that pencils out? You just have to start thinking through the opportunities and constraints to come up with a solution. But it is a very big challenge for a lot of communities.
With that would take us, and if we've got questions on INET, we can talk about them later. I want to get to the CPUC rulemaking process. We started about 10 minutes late, so it's okay. We'll go another 10 minutes, or if you want us to go longer. But I want to get that in, and I'm going to throw it to Gail now. Okay.
Okay, so DIVCA passed the PUC issuing these state franchises. They're for a 10-year term. What they do when you add communities, if you're a state franchise holder and you add another area, they just amend that existing franchise. So your franchise, if you're AT&T or Verizon or the ones that got them right at the beginning, they have a franchise that was adopted in 2007. It doesn't matter really when they came to your community. It matters when they got their franchise. That's a 10-year franchise. And there is a section in DIVCA, it's in 5850, that talks about renewal. And it says a lot of different things. It's not a very long section, but it says it should be really kind of, it suggests it should be streamlined, like the initial process, which basically was fill out a form, send it in, and get your franchise. Then it also says that renewal of a state franchise shall be consistent with federal law and regulations. Now, any of us who've gone through a franchise renewal process know that the federal law is essentially there to protect the cable operator from an unreasonable denial of their renewal, right? It gives them some due process rights. There's two kinds of processes you can go through. You can do it, the most common, it's done almost all the time, is just an informal negotiation. You negotiate, you do some background work that Sue does a lot of, right, and finding out what are the community needs, what are the future cable-related community needs and interests of the community. Maybe you say, you know, we need another PEG channel, HD is important to us, whatever you're going to talk about, levels of funding, that kind of thing, and you negotiate something. If those negotiations go south, there is a formal process that you could enter into. And the formal process is almost like a trial, right? It's very formal, it's expensive, and that's why most communities and most providers don't ever want to get there. Sometimes they start down that path, and then they'll settle it. And that looks at, you look at the compliance issues, you might be saying, oh, we need to improve customer service, lots of things that could be done in a franchise renewal. So what is supposed to happen under DIVCA? This was a question that nobody seemed to want to answer at the PUC. So the first time that they issued an order, they did a general order implementing DIVCA, they said, oh, we'll deal with renewals later. And then later came, and they said, well, a little later. And now they're at the point where they're running out of time. And the reason that they're running out of time is because under federal law, if you're going to, if you're a cable operator and you want to protect your rights under federal law, you have to give a notice during a window that is, you know, the shortest is 36 months out. 30 months, 36 to 30 before the expiration. So if you want to protect your rights to have that trial, if you can't negotiate, you have to give this notice. And so we're bumping up on the time when these providers might have to make a decision about that. And also we're just bumping up on the time of, you know, at some point you have to come up with rules on how this renewal is supposed to happen. So the PUC has issued a rulemaking, and they do this in sort of rounds and rounds and rounds of comments. So first they issued their rulemaking and sought some comments so that then they could develop like a more specific sort of issue list. We represented some communities in the League of California Cities, the California State Association of Counties, yeah, CSAC, and some other local jurisdictions in filing comments. There were all the cable operators filed comments to establish this issue list, which we're still kind of waiting. So there is going to be a whole other round of commenting on on this proceeding, and the issues that they're looking at will not be a surprise to you. It's so what their basic things. What kind of are the main kind of argument that local jurisdictions have been making is that there should, at a minimum, be a notice and an opportunity to comment. And the providers have said, so, you know, different levels of no, you don't have to give any notice, or yes, you notice an opportunity to comment on very limited things, like whether there's some language in the in DIVCA that says the commission shall not renew the franchise if the video service provider is in violation of any final non-appealable court order issued pursuant to this division, right? So issued pursuant to DIVCA. So they say, oh, that's all you can look at. So you can have an opportunity to comment on whether there's some they're in violation of a non-appealable order. On a big scale, what we're really looking at here fundamentally is whether this will be another rubber stamp, and those community needs that were established by the legislature in 2006 are California's community needs for the foreseeable future, or whether there will be some opportunity to actually look at what the providers are doing, look at the level of funding that they're giving, look at all of these requirements that go into cable franchises or video franchises, whether any of that will be open to any kind of a review. The PUC has, they tend to take a very hands-off, other than collecting their regulatory fee, they take a very hands-off approach on this issue. This is not their area of expertise, so there's been a big learning curve inside the commission itself in terms of understanding what all of this is. You know, what reissue franchise? Well, they don't say that, but you know, there's a big learning curve about what this might be about, and so I think it's really important for communities, if you can, take the time to participate and express your opinions in this process, to participate, if for no other reason than just to educate the commissioners on what this is all about and what's at stake here, because the default position, I think is fair to say, would be to do as little as possible, because that's easy, and it also kind of just avoids the issue. And if they don't hear from the community that that's not an acceptable answer, then that will be the default answer.
This is an area where we need to wrap our heads around it, because this could be an opportunity, okay? And because federal law, like it or not, clearly lays out a set of procedures for franchise renewal. And as Gail said, it's formal and informal. But in both cases, essentially, it talks about needs assessment, it talks about performance review, it talks about using that information to try to reach an informal agreement, and if you can't reach an informal agreement, then you go into this RFRP process, which is very complex and complicated. How the state CPUC could possibly, I mean, they could find a way of having some kind of rubber stamp that, oh, we'll take comments, now it's done, now we do a rubber stamp and you automatically get your renewal process. But it certainly would fly in the face of what is in federal law right now with regard to franchise renewal. The other thing I go back to is, if you look at the staff report, the Assembly staff report on AB 2987, which is DIVCA, it makes it very clear that the legislature anticipated that there would have to be fixes to this law. Okay, and it even speaks at one point to the renewal issue. Okay, it seems to me like we need to be on top of this one, because it's sort of like, are the needs and issues of our communities in 2014, which is that's when the first batch comes up for renewal, I think. The first franchises were granted, was it in April of 2007? So that 2014 would be 2017 would be 10 years out. Okay, so we've got a little bit of a window of time here. But think about it, if you were a city, and I'll take Fresno as an example, who was right at renewal, and there are a lot of other cities at the time that DIVCA was passed, and they were in franchises that had been in place 15, 16, 17, 18 years, and they'd been extended because the cable industry knew DIVCA was coming, and they kept getting extensions and not reaching agreement when there was still local franchising authority. So now you're looking at a franchise that may have been granted in 1998 or 1997, and now it's 2017. And you look about the technology changes and business changes that have occurred in your communities, and your community changes, and the needs and interests are the same as they were in 1997 or 95, it's ridiculous, okay? So it's really a conundrum here on this CPUC process. It's also, I find, a very convoluted, icky, messy, unclear process for people to participate in. And Gail, if you can, is there some sort of easy primer for folks if you're a local government, you're in a little bit better position, okay, to engage than maybe some of community groups or community media centers. Is there some place you could direct us as to a kind of, here's how you do it?
Well, they have it.
Docket number?
Yeah, I can find that for you. I should have had that written down, but
it's more than just about knowing what the docket number is. It's the procedure.
Yeah,
it's very convoluted.
It's complicated in ways that seem unnecessary too. Their website is probably one of the hardest ones to navigate. I don't know if you've ever tried to find anything on there, but very difficult to navigate. They have very stringent requirements in the way you file, not the means. They actually use, you can file electronically and you can file, you can serve by email. But the format is like a certain sort of PDF. It's PDF-A. If it's not PDF-A format, then they reject it. All of these sorts of things. But they're so used to being so difficult that they give you a lot of extra chances. So if you get it wrong, then they'll say, okay, well, you did do this and try again and all this. I think they have a service list. You have, if you want to join as a party at this point to the proceeding, they have different statuses, and one is just, you just monitor, right? But if you actually want to make comments, you have to be a party. You have to file a motion. It's very simple kind of motion. You basically say why you're interested in participating, and then they will at some point let you become a party.
But sometimes that point is 3 or 4 months
They
after you originally filed.
But it's retroactive to when you.
Yeah.
Yeah. But they also, and they also don't update their website very frequently. So it's really pretty ugly.
Okay.
Yeah. Or you have it handy?
The CPUC rulemaking number 13-05-007.
That's right, 007.
13-05-007.
Yeah. I remember the 007 part.
Do you have a sense of where the PUC will end up based on talking to their staff? Like a little process, lots of process, somewhere in the middle?
I think what I've heard is that, like I said, it's a real learning curve inside the PUC because it's just not their area, and they know that there's this thing about federal law, so they have to address that. But I think what is complicating is the fact that they don't want, they're mostly worried about, well, who's going to pay for all of this if we have to do something more? So if you look at what their rulemaking talks about, they're saying, well, if we had this kind of a more complicated process, could we charge the provider for it? Like, I think if they can find a way to get somebody to pay, they're more likely to do it than if it has to come out of their own budget somehow. And I do think that there is a general sense that this shouldn't be too complicated. But that doesn't mean that's what the law intended, or how that's a proper interpretation of the law. So we have to go through this process. We have to make the arguments we make about what is an acceptable process, and we've been hammering on that if you are going to give notice and an opportunity to comment, it has to be meaningful. It can't be, don't make people comment and then put those comments in a drawer and do what you're going to do anyway. So how do you make that meaningful? That's a big question. And then once we have the rules, there's an opportunity to challenge them, to go to court or something like that if they're not acceptable. But right now, we've just been in that punt kind of mode. Finally, they're at the point where they're going to have to do something.
To what point is CPUC rulemaking and the process informed or deviled by federal law? You brought up the scenario of the rubber stamping as an example. We could think of other dimensions, but like we had the situation in 2004 where in federal law, the Third Circuit Court overruled the FCC's action for trying to raise media consolidation caps, and that they could not proceed with this sort of thing and ignore public comment.
Well, they have an obligation in DIVCA, right, to renew. I'll read it again. Renewal of a state franchise shall be consistent with federal law and regulations. And the question that they ultimately have to decide is whether that federal law requires. One of the issues, for example, is do they even have to make rules now that deal with a formal process? Or can they only make rules that apply in that informal, we said that, Cable Act has two sorts of processes, right? Do they even have to address, and some of the providers have argued, no, I'm not gonna ask for that. So I'm not gonna ask for formal renewal, you don't have to deal with that, right? That was AT&T. But some of the others have said, oh, no, you don't have to deal with that, that can be later, but eventually later is now, right? So they will have to, they have an obligation under the statute to come up with a process that is consistent with federal law. It's a question of interpretation, and that would be subject to, a court challenge like any other action by a regulatory agency.
So, Gail, could we, is there something that we could put together that we could put on get out to folks about how to file?
Yeah, probably.
I just think that would be very helpful, again, particularly for those who have an interest but are not in a situation where they've got an attorney who can work with them. But if we could put together, and I'll work with you on it, something real simple, step by step. I think that we'll commit to trying to do that because I think it will be helpful for
Yeah,
folks.
the first thing is to get on the service list, so then you at least know what's
And
going on.
that's really pretty easy. I mean, you can to figure that
You
out.
do it, yeah, you do have to file a motion, but it's not complicated. Getting on the service list then will at least keep you up to date with what's going on, because looking at their website doesn't always do that.
Jim?
Yes, the one thing that's a real problem in all of this, when it says consistent with federal law, as Gail, or maybe as Gail at the beginning pointed out, that the Federal Cable Act was written to benefit the cable operators. So there's a lot of mischief a state can do that would, in effect, limit the rights of communities and others and still be consistent with federal law. So, and we've seen this in most of the other states that have adopted legislation since 2005, 2006. You've been hearing how bad DIVCA is. DIVCA is one of the two good statutes that got enacted in that period of time. But they had in Illinois, which kind of copied DIVCA, and most of the rest of the state franchising laws are far worse. So you'll put in a limitation on number of PEG channels, limitation on franchise fees, and since the Cable Act only provides kind of ceilings and process, if the state determines we're going to ask for less, then you're going to be out of luck, which I think makes it all the more important to participate in the proceeding that Gail and Sue are talking about.
Yeah, because ultimately, even if you fail at the PUC, it can create the momentum to get something done at the legislature.
See, and that's kind of what I got rolling around in the back of my head too, is that I fully expect the CPUC will come out with some kind of rubber stamp, very, very little input process, and then it's going to have to go to the next level.
Yeah, this is ancient information, but back in the early 80s, I was part of another advocacy group, and we filed an objection with the FCC to the renewal of the broadcast TV licenses in San Francisco, the three networks and the independent station. We discovered that in order to get a broadcast television license renewed, the station had to fill out a 5x7 postcard and mail it into the FCC, and on the postcard, on the one side that they had to fill out, it asked them to give 5 examples of programming that they did during their 10 years, or whatever, I think it was 10 years, in which they were serving the public interest. To this day, this was in 1983, to this day I remember one of the shows that was listed as an environmental program to the public interest was a cow pie throwing contest. I swear, okay?
About water drinking contest.
Yeah.
I was just gonna say, just procedurally to get on the service list for the rulemaking, I just sent them an email and they accepted it.
They did, but was that before there was a deadline? When the notice first came out?
That was when, I don't recall exactly when it was, but the document that they put out just said, send us something with your name and address and whether you wanted to be a formal party or just for information only.
There was a
I opted for the
deadline.
latter.
There was a deadline to get on the service list
Right.
when it was really easy, and it
Yeah.
may have been then.
Right, it could have been that.
Yeah, And then they said, and that was one of the things, when we actually asked for more time, and we granted a request on behalf of the league and others for more time to file comments in this initial round. And one of the things we asked for was, can we also have more time for people to get on the service list easily? And they said, no, we want to close that list. So now it's a little bit more complicated, although maybe maybe they'll just accept an email, but what we've been doing and what we've seen others do is that they file a motion. It's like 2 pages. Basically says, we really want to participate and we have an interest in.
And basically, what we did was we went and worked with an attorney with Turn, and he just gave us this sort of like really simple thing to get. This was originally to get on the service list. It was very straightforward.
Yeah.
But it's different now. But Turn is another. Those of you who work in front of the CPUC around, Turn's very commonly. They don't get involved in cable a lot because it's very sort of adjunct to the sort of customer protection, consumer protection.
But they did comment.
But they did comment on this.
Yeah.
So that's another kind of group that's been out there and working on this. Well, we have the survivors here. We've touched, I hope, on enough of the areas that you were interested in that brought you here today, that we hopefully begin to answer your questions. We'll be here if you want to chat more and want to get into more depth on anything. Tomorrow morning in the opening plenary session, Gail and Jim will be talking about some of the sort of bigger national broadband and cable issues and what's going on and with legislation and what's going on just in general in the FCC as well. And we'll probably touch just a teeny little bit on the CPUC process, but that'll be more a bigger picture, national picture. But thank you all for hanging in there, and there might even be some goodies left out there if you.
Folks, could you fill out your evaluation form so we can get to the best board?